Mr. Rampele, you're continuing, and I received a request before we started. It's one of the reasons why we've come in now, to give you an extension of an extra 10 minutes, because there's a point that you hadn't been going to deal with earlier, which you think you have to deal with. And I indicated that I'd give you those 10 minutes. Please, no more than that.
Thank you, Chair. Thank you very much. Chair, we're still responding to the issue of the duty of care of the employer and the proposition that has been put forward by Lonmin that in these circumstances, the principle enunciated in this case should not apply. And we say that in relation to this case, what the court held, and that is you, Chair, you said what is important, and you referred to an Afrikaans judgment, Minister van Polisie versus Evels, where what you considered important as the rechtsoortuiging van die gemeenskap, wat die gemeenskap verlang dat die late as onrechtmachtig beskou. My trying to translate that would be that you're looking at the legal conviction of the public and what they yearn for, that the omission be regarded as unlawful. So in these circumstances, I think that if one takes that into account, but not only that, after 1994 we operate in a constitutional state where the right to life, if has to be limited consciously, one has to say, does the limitation of the right actually pass the constitutional muster? That is the limitation clause of the Constitution. And I don't think that the risk, the conscious risk of lives of the employees of Lonmin actually pass the constitutional muster. But Lonmin makes a very interesting proposition. The proposition is that on financial grounds, you can take a conscious decision to limit the right to life. Or, because of ventilation in a shaft, you can actually risk the right to life. Or, because there may be a methane explosion, you may limit the right to life. Now, constitutional interpretation has to be taken into account. Can a right to life be consciously limited in a commercial setting because there is possibility of an explosion, or there is a problem with ventilation, or there is financial consideration? But what interests me is actually the financial consideration. Because if we take this proposition further, then there is a limit to which this commission has to make some sort of determination. In a commercial setting, how much is worthy of a risk to a right to life? Say, for argument's sake, the closing of a shaft was going to cost 2 billion. And the right to life of Langa or Mabebe, if one looks at the damages that one has to pay in terms of loss, is 200,000. The proposition is that because we are going to lose 2 billion, we have a very reasonable consideration that says we can forgo 200,000. And we can forgo actually a number of 200,000 because otherwise we'll lose 2 billion. And I'm saying it cannot be a consideration that is justified to risk a right to life. So even with the propositions that have been put forward, Lonmin would still not be justified to risk the right to life. And I mean, most recently, we've had the most, as an example, the most, what one can call a world calamity in the form of Ebola. And we know how it's resolved. You quarantine it. If the 3,000 strikers were as dangerous as that, then there was a possibility to actually just quarantine the problem. And I think the issue of taking the right to life as opposed to isolating the problem it was actually not considered.
I know that's right in approaching this matter to consider that there would be 3,000 strikers. That, according to the evidence, was something that had never happened. 3,000 strikers armed, dangerous mood and that kind of thing. According to the evidence, that had never happened before. And they argue that it was not reasonably foreseeable. But prima facie, I think you're on stronger ground when you say that if the Lonmin board was faced with a business decision, do we accede to the request from our security people to provide them with an armoured vehicle and equipment which will protect their lives in circumstances where their lives may be threatened? It is a very difficult proposition to justify it. You can say, well, never mind, we'll take the chance that they'll be killed, but we'll save money in the process. If that's the way that the matter was approached, there may well be substance in your contention that that wasn't a proper approach for the Lonmin board to take. But I don't think you can take 3,000 strikers into account, because that was not something, to be fair, that they could have foreseen, reasonably have foreseen, at the time they made that decision. And that's just a prima facie response to what you say. If you disagree with the prima facie point I put you, then obviously you must put me right and show me why I'm on the wrong track at the moment.
Let me actually make a point in relation to that I was going to make, Chair. There is a proposition that has been put before you that actually the armored vehicle would not have made any difference. But we have evidence before the Commission of, I think it's Mr. Lowe, who was involved in the skirmish with the strikers, managed to get out with a soft skin vehicle, and then tried to go back in to rescue Mabelane and Fundi. Now this time with an armored vehicle. And there's evidence before the Commission that he tried to leave the armored vehicle. The strikers attacked him, and because he managed to go back into the armored vehicle, his life was saved. So that proposition I agree with, that the decision not to purchase armored vehicle is a decision that was actually putting a lot of vulnerability on the security establishment, and armored vehicle, if purchased, would have made a difference. And in this particular case, the company did not take reasonable steps to heed the call for armored vehicle.
In the light of the request they'd received from their own security people, which was motivated, they can't be heard to say that injuries to or even death of their security people was not reasonably foreseeable when they made the decision they made.
Yes. Thank you, Chair. There is another issue that Lonmin raises, and that is the issue of Mr. Mabelane. Again, this issue is an issue that the family is very concerned about, because it is an issue where Lonmin is saying Mabelane was actually wrong, and that's why he died. Now, firstly, we have a situation where Mabelane is not here to respond to that. The facts that we have is that Mabelane received training of 3 months of about 19 courses. And in the 19 courses, there was crowd management. That is the formal training he received.
There's some evidence. You can put me right if I'm wrong. Isn't there some evidence that his colleagues who were actually involved on the scene that day didn't agree with what he was doing? They considered it prudent to retreat, and he didn't do so. He was obviously very courageous in doing what he did, but the impression we get from the evidence, whether it's a correct impression, is something you must deal with if you have to, but that he was actually over-courageous, that he was in fact overconfident that he could deal with the situation when the other people thought that the situation was so dangerous that he should have retreated as well.
Yes. We'll get to that.
I'm reminded the other colleagues said they'd never seen him so firm about a decision of that kind before. These are all factors we have to bear in mind, but
yes.
not so. And
yes.
that evidence would tend to support the submission that Lonmin's put up.
Yes. Okay. Thank you, Chef. The first issue is, and that is, it relates to the duty of the employer. Does the employer send an employee that is not trained to a situation that Mabelane was sent into? And if one looks at this Media 24 case, but if one considers even international principles of law, like for instance, I think in my argument I may have mentioned some of the practices where, especially you have that UN will send their own staff to very dangerous situations. And because of the dangerous situations, there is an international principle that is accepted, that it is the employer's duty to investigate the danger of the situation in which they send their employee. It is not the employee's obligation. It is the employer's obligation to investigate the degree of danger into which they send their employee. And
wasn't the evidence that Lonmin said to their security people, don't endanger your own lives. You obviously do what you have to do, but don't do so in a manner which endangers your own life. Wasn't that the evidence?
They may have said that, but we also have to consider exactly when that was said. That was said a day or two before the 12th of August. And this was said as some form of training, according to Mr. Sinclair, under cross-examination by Advocate Pillay. Clearly, if that has to be considered as training, and he was talking in the context of how cars should be parked in a situation like that, the question is, now you have 3,000 strikers that are angry, that have injured people. You have had a 10-minute session informing the commander as a form of training how they should conduct themselves in that situation. Can that call that training? And my proposition to you, Chair, is that it would not be adequate, especially because the investigation that the employer has to do first is, what is the situation I'm sending this employee to? I'm sending the employee to a situation where they are probably carrying some guns with bird shots, and the crowd has clearly demonstrated that they have been bolstered by the non-visibility of policing, and they just move into any situation, and they have even attacked. In this particular case, before Mabelane was attacked, Lowe and Foster were attacked. There was the armored vehicle had to vacate from the area. Communication was sent that the ambulance should not go into the area. So there was knowledge of the danger that Mabelane and his team would have to face, especially in view of the training that Mabelane had. And we say that when we judge the duty of the employer, we don't judge it according to a reasonable man or reasonable employer test, especially if the danger that is being posed or the right that is at stake is the right to life. In this particular case...
I'm sorry, I don't understand that solution. You say you don't judge it by the standard of the reasonable man because there's a danger of death.
No,
but surely the reasonable man would act appropriately if there was a danger of death. He would be more vigilant, take more trouble to ensure that the fatal consequences that might otherwise flow don't flow.
No.
The standard of the reasonable man is dependent upon the circumstances. Is that so?
Well, the standard that we're talking about is not the standard of Mabelane. The case talks about the standard that one judges the employer. And the standard that we judge the employer with is not confined to just the reasonable test. It is confined to the right at stake. And if the right at stake is the right to life, and you knowingly put your employee in a situation of that nature, then we don't judge the employee. And I've mentioned actually it has even, I think, case laws in Europe and in other international jurisdictions have held that not the employee is judged. The duty rests with the employer. The employer must investigate the extent of the danger. When the employer sends an employee into a dangerous situation, then it is the employer, not the employee that is judged, it is the employer that is judged. So the employer does not say to the employee, take care of yourself and send them into a dangerous situation where their life may be lost, and then say in response, well, he was supposed to act reasonably. He didn't. I said he should run away. He didn't. That is not the test. The test is when you send the employee out, did you take reasonable steps? And in this particular case, with all the facilities, the equipment, the technology that Lonmin had, with all the intelligence, with realization of the danger, did they actually take reasonable care to make sure that Mabelane's life was not in danger? Chair, I will move on to two last points.
I'm afraid you won't be able to because your time is up. I gave you 10 minutes initially.
But you have been interrupting me, Chair.
I'm sorry, but I didn't interrupt you. I put questions to you so that you could answer the difficulties that I had, prima facie difficulties.
But Chair, I have to make the last point.
Well, make it in 1 minute. You've submitted written heads, which we have read and will read again. Make the point, just state the point in one or two sentences, and then I'm afraid you have to stop.
Then, Chair, please don't interrupt my 1 minute.
The other people, I haven't started your 1 minute yet. The other people waiting, who also need time to present the case for their clients. Your minute starts now.
Chair, I was going to praise you at the end, but I'm not sure now.
I will take such punishment as you choose to dish out to me.
Marikana is a test of constitutional values of the country. you're dealing with a situation where you have a community in Mines that is confined to a very small area. We've heard that Lonmin says that you have about 28,000 employees confined in a very small space. This massacre has affected these many people that are in the small space. Some of the illustrations thereof is what happened in the first inspection in Loco. It is, if you look at our submissions, we propose a restoration fund because this is a commission that has to also look at restoration. And that restoration must be, and this is practice in Lonmin. Mrs. Langa's child may actually go back and work where the father used to work. One of the strikers' child may also do the same. The question is, if we leave the situation as is, don't we perpetuate the gap that has been there between the families? And the request for consideration and recommendation of a restoration fund is to have all the stakeholders trying to contribute to a situation where this unfortunate incident does not leave communities in Marikana having this char between them, the divisions between them. So we believe that if, say, all the stakeholders, including Lonmin and trade unions, can contribute not only a fund, but a process of restoring relations between families. Because I am going to be, I've spoken to my clients on the issue of, because life has been lost, and our constitutional values say that we must try and have communities that live together, including with the employer, including the unions, because that is what plural, that be difficult English word, but that is what different views how they should coexist in a constitutional democracy together. And we believe that if that fund is created, then we will be able to go beyond this commission with some sort of confidence that we will not have another Marikana. And my families, in the spirit of Ubuntu, would also, because we've not done that, and I think Mr. Mpofu has actually done that, and Mr. Matunja has done that, we pass our condolences to those families that have lost their loved ones. We know that the strikers, some of them were involved in the killing of our own families, but we're saying that the law should take its course. We all agree to that. The police must investigate, but beyond that, these families have to live together. And the commission is an opportunity to make sure that that happens. So that is where we then believe that maybe if the chair doesn't want to give us one more minute, we'll leave it.
I'd given you substantially more than one more minute, but the point you made was the point of substance. I'm glad you made it, and thank you very much. Ms. Barnes?
Yes, thank you. Chair, Commissioners, my learned friend Mr. Gotts and I will be sharing the argument on behalf of AMCU. I will be addressing issues relating to AMCU and Lonmin, and Mr. Gotts will address you on issues related to NUM and the police. We will each address you for about an hour, and then we will hand over to Mr. Nzabeza, who will present the argument on behalf of the families. Chair and Commissioners, we have prepared a document which records some of our key oral submissions, which we would like to hand up after our argument.
Thank you. That will be very helpful.
If I might then give you a roadmap of what I intend to cover in my oral address. I will begin with AMCU, and I will begin by making some introductory remarks about AMCU's conduct generally in the week of the 9th to the 16th of August 2012. Thereafter, I will deal with what appears to be the only remaining allegation of any materiality against AMCU, and that is the allegation that AMCU was seeking to exploit the situation at Marikana in order to get bargaining rights at Lonmin. Finally, then, in relation to AMCU, I will deal with a new submission which has emerged in the heads of argument of our learned friend, Mr. Gumbi, to the effect that AMCU is liable in law for damages caused by its members during the strike. That then deals with AMCU. I'll then move on to make some submissions in relation to Lonmin. There I will make submissions on Lonmin's claim that the strikers' demand for 12,500 Rand was not negotiable. And then finally, I will address you on the basis for our submission that there's a prima facie case or prima facie grounds for finding that Lonmin is criminally responsible for the deaths and injuries committed by SAPS on the 16th of August on the basis of accomplice liability. Commencing then, Chair and Commissioners, with AMCU.
Carry on. I'm afraid the problem we had yesterday has recurred. There's some headphones that are on too loud, and we can hear the voice all the time, and it's very disturbing. Please, they must be turned off, because alternatively the person concerned has got them as ensure that they're not audible generally in the chamber, because it's very difficult to follow what Ms. Barnes has to say if there's another voice going on in the background. I still hear it. Is there anyone who hasn't got his or her earphones on, which is what we can hear, or is it just a question of the volume being turned up too loudly? I think we'll adjourn for a couple of minutes so the problem can be sorted out. Commission resumes. Sounds as if the problem's been solved. Response?
Thank you.
Thank those responsible for solving the problem. I know these things aren't easy, and I know there are some people who are hard of hearing and they have to have the earphones up as loudly as they can so they can hear. I'm very sympathetic to that, but nevertheless, I do want to hear the arguments without undue distraction. So I understand a lot of efforts have been made to solve the problem while we were outside, and I'm grateful to those who assisted us. Response? Would you like to take advantage of the labours that have been performed on your behalf during the short break and present your argument?
Yes, thank you very much.
As you can.
Chair, Commissioners, when this Commission commenced a little over 2 years ago now, AMCU was the villain in this story. We heard that AMCU was the militant new union that was engaged in a violent turf war with NUM at AMCU. We heard that while it refused to admit it, AMCU was in fact behind the unprotected strike. We were told that the strike reeked of AMCU's involvement by Mr. Russo Bello of Lonmin. Mr. Mokoena told General Mbombo, the Provincial Commissioner of the Northwest Province, that Lonmin could prove that AMCU was in fact behind the strike. All of this has been shown to be false.
We never got that tape recording as to be the proof. That's never been explained to us either.
Indeed, it's never materialised.
It's a fact you're entitled to remind us of.
Indeed, it's never materialised, and of course Mr. Mokoena readily admitted that he'd never in fact heard it himself. We haven't heard evidence from anybody who did actually hear it. We submit that whether it was ever in fact in existence is questionable. The evidence that has been led in this Commission has established, we submit, that there's no basis for any suggestion that AMCU was behind either the demand for 12,500 rand or the unprotected strike or the violence that followed it. And we note, Chair and Commissioners...
I don't want to interrupt you unduly, but am I correct in saying it was never put to Mr. Matunzwa when he gave evidence by anybody that AMCU was responsible for what had happened?
That is quite correct, Chair.
That's obviously quite an important fact in itself, is it not?
It is indeed. And the allegations, in fact, there were rumours, and there was a lot of reportage in the media to the effect that AMCU was in fact behind the strike. But the allegations came from Lonmin rather belatedly. We deal with that in our heads of argument. The direct allegations, as you correctly point out, Chair, were not put to Mr. Matunjwa, but appeared in detail for the first time in Mr. Mokwena's supplementary statement. It appears that he was that arose as a result of the transcript of the conversation between him and General Mbombo, in which those allegations had been made. And so, because the transcript surfaced, it appeared that it was felt necessary to deal with the matter and make the allegations in his supplementary statement. But he of course retracted all allegations that AMCU had been behind the strike. And we note, Chair and Commissioners, that the evidence leaders come to the same conclusion in their heads of argument, to the effect that AMCU was not behind the strike. They do so in paragraph 1254 on page 668 of their heads of argument. Now, we submit that the evidence that has been led in the Commission has established that, far from being the villain in the story, the response of AMCU's leadership to the crisis that unfolded in Marikana during that week was responsible and constructive. And I need to address you briefly on that submission. As soon as the unprotected strike commenced, Mr. Matunjwa proposed a meeting between the recognised unions at Lonmin and Lonmin management in order to discuss the problem. Now, Lonmin says in its heads of argument that AMCU was not entitled to do this because AMCU was not entitled to bargain wages at Lonmin. And therefore, by proposing this meeting, Lonmin was in fact trying to exploit the situation. AMCU was trying to exploit the situation. Thank you, Chair. Now, with the greatest of respect, there's no merit in this submission. We must remember that although AMCU didn't have the right to bargain wages at Lonmin, it had a majority of members at one of Lonmin's mines. And it had a whole host of rights at those mines. It had officers there. It had shop stewards. It had the right to hold mass meetings. It had the right to raise grievances. And it had permanent representatives on a whole host of Lonmin forums and committees. And so we now had a situation where AMCU members were involved in this unprotected strike. It was an unprotected strike, which was itself a problem. It was also a strike outside the structures, which was an additional problem. And we submit that there can be no doubt that AMCU was in those circumstances entitled to propose a meeting to discuss the problem which involved its members. That's what it then did on the very first day that the strike commenced. That proposal, of course, fell on deaf ears. AMCU then made the same proposal for a meeting of all relevant stakeholders to discuss the matter 5 times during the week of the 9th to the 16th of August. We submit that those calls should have been responded to with greater and greater urgency as people started dying. Instead, they fell on deaf ears. If we can look at other steps taken by AMCU during that week. On Monday, the 13th of August, Lonmin asked for AMCU's intervention. And here we make the point, and it's really the flip side of Lonmin's submission, that a number of actions taken by AMCU were inappropriate or unacceptable because they didn't have the right to bargain wages at Lonmin. AMCU didn't say, well, no, we know that our members are involved in the strike. We hear that there's been violence and deaths, but no, the strike's over wages. We don't have the right to bargain wages, and so no, we won't. We won't come and intervene. And in fact, we submit that had they done so, it would have been a cynical position to have adopted. It would have reflected poor leadership. And they may well have been open to criticism that they hadn't used their best endeavours in relation to the matter. But of course they didn't do that. They readily agreed to intervene, and Mr. Matunjwa immediately sent his General Secretary and the National Organiser to Lonmin on that Monday morning. We know that they then met with the strikers, they met with Lonmin management, and we know that in the meeting with Lonmin management, AMCU denounced the violence that was happening at the mine. The following day, on the Tuesday, the 14th of August, AMCU publicly denounced the violence that was happening at Marikana. And then the following day, on Wednesday, the 15th of August, Mr. Matunjwa responded positively to Mr. Gwala's invitation to participate in the debate, SAFM debate, in which Mr. Gwala quite correctly and commendably was concerned that some sort of solution be found for what was now clearly a crisis. And during that debate, Mr. Matunjwa proposed that all the stakeholders meet and then go to the Kopi and address the strikers. And we stress that it was Mr. Matunjwa, if one reads the transcript, it was Mr. Matunjwa that made that proposal for the first time. It was not, in fact, Mr. Gwala. We deal with this matter in some detail on pages 41 and 42 of our heads of argument. Now, the proposal that the stakeholders all meet to discuss the problem was in fact the 4th time that Mr. Matunjwa had made that proposal in this week. Mr. Matunjwa then made good on his promise to address the strikers on the Kopi on the 15th of August 2012, and then of course he did so again twice on the following day, the 16th of August. And there it's important to emphasize that he did so in exceedingly difficult circumstances for 3 reasons. When he went to address the strikers on the Kopi for the first time on the 16th of August, he did so despite the fact that the undertaking he had sought from Lonmin earlier that morning had not been given. And I'm going to get into that in some detail in a moment. So that was the first thing. The second thing was that he went to address the strikers despite the fact that he had to tell them that Lonmin's commitment that he'd received the day before, that they would engage with the strikers' grievance if they returned to work, was now no longer. They'd effectively reneged on that commitment. And he also went to the Kopi on that occasion on the 16th of August without any police escort. So despite all of that, he went to the Kopi. It's clear from the transcript that he attempted to persuade the strikers to put down their weapons, end the strike, and go back to work. We know then that he attempted to communicate with Lonmin, and there was important feedback that he needed to give Lonmin at that stage. And I'm going to get to that aspect in a little detail later on. But when he Lonmin refused to receive the feedback and indeed refused to speak to him. The police would no longer engage with him. He then went back on a second occasion, and he went down on his knees and he begged the strikers to leave the koppie so that they would not be killed by the police. Now, finally and crucially, Chair and Commissioners, in this vein, on the 16th of August, at the meeting with Lonmin in the morning, Mr. Matunjwa proposed that a forum be set up outside the established bargaining structures on which AMCU would have a place and at which the RDO issue could be discussed. Now, yesterday, my learned friend, Mr. Berger, said that Mr. Matunjwa and Mr. Zakwana were opposed to Lonmin engaging directly with the strikers. And then he said, to quote him, "They didn't say, let's have an ad hoc tribunal to solve this problem." Well, we submit that while it's true that AMCU was initially of the view and initially took the position that the matter should be dealt with through the structures, this is precisely what Mr. Matunjwa was proposing on the 16th of August, an ad hoc tribunal to solve the problem. That's precisely what the Central Forum was. And as the Chair noted yesterday, an important counterfactual to consider is how the strike was ultimately resolved. It was, of course, resolved through the establishment of a forum outside of the collective bargaining structures on which the workers were themselves represented and at which AMCU had a seat. The Chair put this to my learned friend Mr. Berger yesterday, and his response to that was, well, that was established in the context of an entirely new ballgame. 34 people had now died. Why, we ask, and this is the critical question to which Lonmin has provided no answer, why did the death of 10 people not constitute a new ballgame? So we submit that, quite simply, had Mr. Matunjwa's proposal for the establishment of a central forum been accepted by Lonmin, as it should have been, the massacre would have been averted. In summary, then, Chair and Commissioners, on this point, we submit that the response of AMCU's leadership to the crisis at Marikana during that week was responsible and constructive, and that AMCU ought to be acknowledged for this. Now, many of the allegations that were initially made against AMCU have been retracted or have been shown to be false. We note in this regard that the police do not appear to persist with their allegation that Mr. Matunjwa gave an undertaking on the 15th of August to the police that the strikers would lay down their arms and return to work at 9 o'clock the next morning. They certainly do not persist with it in their heads of argument. We note that the evidence leaders find correctly in our submission, and I quote, "There are no facts to support the assertion by SAPS that Mr. Matunjwa gave an undertaking that the strikers would voluntarily disarm and disperse by 9 o'clock the next day." This is on page 670 of their heads of argument at paragraph 1261. So we submit that that's correct. It's not supported by the evidence, and it appears that SAPS, in any event, no longer persist with it.
Even during the course of the evidence, General Annandale conceded that there wasn't an undertaking. Mr. Matunjwa may well have been optimistic. He certainly was. He may have been over-optimistic, it appears to have been. But General Annandale made it clear that he could not say an undertaking was given. So even from the very beginning, it wasn't a firm line adopted by every police witness that an undertaking had been given.
Yes, that's quite correct, Chair. So we submit that the only remaining allegation of any materiality against AMCU is the allegation that it was attempting to exploit the situation at Marikana in order to obtain bargaining rights to which it was not entitled. We note that the evidence leaders find that there is evidence to this effect. They appear to accept that AMCU was in fact attempting to exploit the situation. They do find, though, that despite this, AMCU, there's no basis to hold AMCU morally or legally responsible. And they note that the evidence clearly suggests that irrespective of the reasons for doing so, Mr. Matunjwa did everything in his power to convince the workers to disarm and return to work. But we submit with respect that the evidence leader's conclusion that AMCU was attempting to exploit the situation is wrong. And I will attempt to demonstrate that now.
There's another point you must deal with as well, and that was whether Mr. Matunjwa's evidence initially as to why he only went to the copy at 12 o'clock, what happened, what the reason for the delay was, whether that evidence was truthful. Because you remember the evidence was that, for some reason that's not very clear to me, despite the fact that the transcript had been made available, the transcript of the discussion was made available, he hadn't read it beforehand before he gave evidence. And it was only when he was confronted in cross-examination with the transcript that certain other facts came to light. So that's an aspect you have to deal with as well. But of course, the main point you make is that twofold. One is your argument is he wasn't asking for bargaining rights, but merely a presence, the right to participate in the ad hoc forum. I think that's the first point you make, is it? And the other one is that whatever else there is, it's to his undying credit what he did at 3:30 when he went on his bended knees and pleaded with him to leave the copy. No one else did that.
Indeed, Chair, and we submit that that's significant in the sense as well that that does demonstrate his true intention. Lonmin makes the allegation in their heads of argument that once he couldn't get the undertaking he sought, he was no longer prepared to assist to resolve the impasse. I mean, that's clearly not correct. He still went back to the copy and did his best to persuade the strikers to leave. Well, Chair, we submit that the two key reasons for the evidence leaders, there are two key reasons for the evidence leaders' conclusion on this point. And the one is precisely what the Chair has just alerted me to now. Their contention that Mr. Matunjwa initially gave a false account of the meeting. And then the second critical aspect that they rely on to come to their conclusion relates to Mr. Sidat's evidence. So it's on the one hand their allegation that he gave a false evidence initially, and secondly the conversation with Mr. Sidat. And I'm going to deal with both of those aspects in turn, if I may. So if we consider first the first aspect, the evidence leaders find or make the allegation in their heads that he and Mr. Matunjwa initially gave a false account of the meeting held at Lonmin's LPD offices on the morning of the 16th of August. Now, we have two answers to that. The first is that while it's true that Mr. Matunjwa's statement does not deal with this in any detail, one must be remembered that this wasn't in fact a formal meeting. This was in fact this all happened in the foyer of the LPD offices, and it was recorded by Mr. Kwadi, but it was people sitting around in a foyer and having this discussion in that context. Chair and Commissioners will recall that when I cross-examined Mr. Sidat on this, he was adamant that he hadn't walked into a meeting, but in fact he had. It was clear from the transcript. So this was not a formal meeting. It was a discussion between the parties. We point out that Mr. Matunjwa's statement does not, nor could it be expected to, record the full detail of every informal discussion that happened between the relevant parties during that week. So that's the first point. The second point, and the more fundamental point, is that we submit that Mr. Matunjwa does not, if one looks at the evidence holistically, he does not contradict himself in this regard. So what he is adamant about is that he was not seeking bargaining rights for AMCU at Lonmin in the formal sense. And we've pointed out in our heads of argument that as a matter of law, those could not be simply conferred on him by Lonmin. And he gave clear evidence in that regard. He said, I know how that works. I know that they couldn't just give me bargaining rights. That's not what I was asking for. On the other hand, what he's never denied in his evidence is that he wanted to be part of the solution to the problem, and that involved a forum and AMCU having a place on that forum in some way. So his evidence is clear if one looks at it all about what he says he was not doing and what he says he was doing. The only passage that the evidence leaders rely on in his evidence to suggest that there is a contradiction is we submit incredibly unclear. So they refer to that in their heads of argument. It's day 24, page 2550 and 2551. And I'm not sure that it's necessary to go to it, but that's the only alleged contradiction in his evidence that they refer to. And if one looks at it, it's Mr. Berger is cross-examining Mr. Matunjwa, and it's not clear during the cross-examination whether Mr. Matunjwa is being asked what he was going to tell the strikers at the Kopi or what he was going to tell management at Lonmin on the morning of the 16th. So it's an unclear passage, and we submit does not support a conclusion in the context of all the evidence that Mr. Matunjwa contradicted himself on this aspect at all. If we turn then to the issue relating to Mr. Sedat. Now, here again, we submit with respect that the evidence leaders fail to appreciate significantly or sufficiently the difference between seeking bargaining rights and seeking to be part of a negotiated solution at Lonmin. And the evidence leaders make the following submission in their heads of argument. They say that, and it's important that I read it, they say, we submit that in view of the fact that AMCU did not challenge Mr. Sedat's evidence that one of the issues touched on during the brief discussion between him and Mr. Matunjwa was bargaining, the Commission ought to make a finding that bargaining was discussed that day. Now, we submit with respect that that's not correct, in the sense that Mr. Sedat was indeed challenged on that in cross-examination. So the reference there is day 293, page 38379, line 25 to 38380, line 14. And I'm cross-examining Mr. Sedat, and I put it to him in terms that I refer to the words that Mr. Sedat uses, which were, give me a place at the bargaining table and I will get the workers off the Kopi. And then I say, Mr. Matunjwa has testified in the Commission that he did not use those words to you. Do you understand that? And Mr. Sedat says, I wasn't there, but if he said it, yes, okay. So that Mr. Matunjwa said that to Mr. Sedat was clearly challenged in cross-examination. It was put to Mr. Sedat in his cross-examination that in the informal discussion that he'd walked into, which he hadn't realized at the time, but 2 minutes earlier, as appears from the transcript, Mr. Matunjwa had confirmed in his conversation with Mr. Kwadi that what he wanted was a central forum to be established and for AMCU to have a place on the central forum. And it was put to Mr. Sedat that in the circumstances he could not have been sure whether Mr. Matunjwa was asking for a place on the bargaining, at the bargaining table in the sense of bargaining rights for AMCU at Lonmin, or for a place at the central forum. While Mr. Sedat did not concede this, he did concede that he was not sure of the precise words that had been used by Mr. Matunjwa. At times he said it was bargaining rights. At other times he said negotiating table. Those were two different terms used by him. And it was also clear, even while giving his evidence, that he didn't appreciate that there was an important difference between the two concepts, at the very least in the context of the discussions that were taking place. So we submit that in those circumstances, Mr. Sedat's testimony cannot constitute evidence for the conclusion that Mr. Matunjwa was seeking bargaining rights for AMCU at Lonmin. That's really, we submit the basis on which, the only possible basis on which, those two bases, the only possible basis on which it could seriously be contended that there's any merit in this argument. And we submit that once they fall away, there is no basis for the allegation. If I might then deal briefly with the new submission that appears in the heads of argument on behalf of our learned friend Mr. Gumbi, on behalf of Mr. Lepaku and Mr. Beloy. They make the submissions in paragraphs 106.13 to 106.14 of their heads. And they basically say that AMCU and NUM are liable in law for the damage caused by their members during the strike. And we simply make the point here that, first of all, they refer to quite a lot of case law in support of that. And they start with the Constitutional Court case of Satawi versus Jarvis, which I think Mr. Gumbi referred to in his oral argument the other day. Now, that, of course, is not applicable. That was a case in which Satawi had, in fact, arranged the gathering. And in fact, all the further cases the same difficulty arises in respect of all the further cases that they rely on. They're all cases in which the union has, in fact, arranged the gathering or has called the strike. That was not the case here, and so those cases cannot apply. So they don't lay any basis in the body of their heads for their submissions in this regard. But in any event, the case law that they rely on is inapplicable. So we submit that there's no merit in that.
In fact, in this particular case, the unions have distanced themselves from the strike. So they were in no way involved. Instead, they were trying what they could do in order to avert the strike. So the basis for the liability is actually not there, as was in those cases that were referred to by Mr. Gumbi. That's your...
Indeed, Commissioner Tukorta. With respect, that's exactly correct. This was a case in which the evidence shows that the union members, in respect of both unions, had explicitly rejected their involvement, had acted on their own, and that there's absolutely no evidence that to the contrary.
And the strikers themselves said that we don't want unions to be involved at all.
Indeed.
I thought, if I may say so, that you summarized your submission very neatly in one sentence when you said they weren't acting qua AMCU members, which says it all really, even in less than the minute that I gave your learned friend earlier today.
Yes, I believe we said so in our heads of argument. Thank you, Chair. Chair and Commissioners, if I might then move on to make some submissions briefly in relation to Lonmin. Lonmin spent a great deal of its argument yesterday seeking to justify its decision not to engage with the strikers. Now, we submit that it had a duty to engage by virtue of the protocol, as Mr. Berger termed it. And we've set out our reasons for our submission in this regard in detail in our heads of argument. I'm not going to repeat them here, but we submit that even if that is wrong, that it acquired a duty to engage at the very latest by the 15th of August, when SAPS implored it to engage because 10 people had died and it was necessary in order to avert further bloodshed. And that is essentially what General Mpembe says in the meeting of the afternoon of the 15th of August. At the very latest, by that stage, Lonmin had a duty to engage in our submission.
Remember, Mr. Berger posed the question, what was the source of the obligation to negotiate? And I asked him for his submission the question of whether the source was not a request from the police, whom they invited there to restore law and order. Police say, in order to do our job, you must help us by negotiating, at least talking, perhaps negotiating is the wrong word, there's be a fight about what that word means, but at least talking to the strikers. And of course he didn't accept that proposition, but do you say that it's a correct proposition?
Indeed, Chair. I mean, one sees from what General Mpembe says in the meeting of the afternoon of the 15th that he says to Lonmin and to the two unions, there needs to be engagement in order to avert further bloodshed. This engagement is the last hope. Otherwise, there will be further bloodshed. I mean, it's absolutely clear. At that stage, there can be no doubt that there was a duty on Lonmin to engage.
Say about their argument that I don't want to take you out of the argument that you've prepared. But what do you say about the argument that would be a very unwise course to adopt, because there was a bit of hyperbole, but the suggestion was that there may be substance behind the hyperbole, and that is that it makes nonsense of the Labour Relations Act, it makes nonsense of the collective agreement, and once you agree to talk to violent, armed, unprotected strikers in the face of a collective agreement, in the face of all the other things they had, that would be, in the long term, would be have very deleterious effects. And as he put it, it would cause chaos. I'm not sure if he used the word chaos, but he used similar word, paralysis possibly, in the whole platinum area. Now, that's a very strong submission made by Council with all the emphasis at its command. I take it you're going to deal with that.
Yes, Chair. We would submit that it wasn't a normal situation. It was a crisis. It was an extraordinary situation that required an extraordinary action, and that had to be engagement in the circumstances. That's the one. The one answer is it was because it wasn't a normal situation. The normal rules and procedures were no longer applicable. Something different had to be done, and the obvious thing was for everybody to sit down and talk. And the second answer is that that's what ultimately was done. Ultimately, there was a structured engagement, and that's how the problem was ultimately resolved. And I think Chair, you pointed out yesterday that didn't result in the collapse of collective bargaining systems or.
Fair. Mr. Berger replied saying that was done under the shadow of, I'm not sure whether he said 34 or 44, but under the shadow of a great tragedy which shocked the world, not just South Africa, and you could understand people's attitudes being changed. I think that was his answer. So I don't know how you deal with that.
Yes. Of course, our answer to that, Chair, is that 10 people had already died by the 15th, and that was sufficient reason to engage in an extraordinary process of engagement. Chair and Commissioners, we submit, though, that Lonmin needs to be judged on what it didn't do, but also on what it did do. And when one takes these things together, a rather disturbing picture emerges, we submit. Because Lonmin did not engage with the strikers, but what it did do is it spread misinformation about the strikers. It claimed not to know who the strikers were, calling them faceless. It claimed that AMCU was behind the strike. It claimed that the strike was caused by rivalry between AMCU and NUM. All these claims were false, and Lonmin made these claims while knowing them to be false. Now,
is that correct? I could understand your point about the facelessness of the strikers, which is obviously obvious nonsense, and that was not seriously persisted in, I don't think. But I must confess that I get the impression that Lonmin believed that AMCU were behind the strike. And I think they believe, again, this is a prima facie perception. One of the reasons why we're having oral hearings is so that prima facie points can be put on the table and dealt with. I also get the impression, prima facie, that Lonmin believed that there was rivalry between the two unions. One gets that from those other documents that were put in. I think your side actually put them in, the scenario and that sort of thing. So I'm not sure it's fair to say that Lonmin deliberately spread misinformation. I say deliberately spread misinformation that AMCU were behind the strike, and that it was because of the rivalry between AMCU and NUM. I think, maybe that I'm overlooking important factors, which you'll obviously put to me, but
Chair, if
I wasn't aware of any evidence which indicated that Lonmin didn't believe it at the time.
Well, Chair,
there is, of course, that bit about the recording that they claimed to have, which we never saw. But I'm not sure there's anything else. But anyway, but other factors that you've got are relevant in that, obviously, you must give me.
Chair, two responses to that. The one is that, during our cross-examination of the Lonmin witnesses, we went through the reasons why the strike happened. We went through the facts relating to Impala, the facts relating to RDOs at Lonmin being underpaid. And it's clear that a story is told about how the strike at Lonmin happened. Those facts were all readily conceded to by, in particular, Mr. Da Costa and Mr. Mokoena. They understood those facts, and they were aware of them at the time, and they conceded that they were very concerned that because of what had happened at Impala, the same thing could happen at Lonmin. There was never any suggestion by either of them that the true cause of the strike was somehow as a result of rivalry between the two unions. So there's never been any evidence to that effect from Lonmin. In relation to the allegation that AMCU was behind the strike, that we've dealt with earlier this morning. There's no evidence.
I'm sorry, there was also some evidence, as far as I can recall, from Mr. Da Costa to say that though the people at Korea said they were acting outside confines of union activity. And though people involved in Korea were both members of AMCU and members of NUM, there was a suggestion that the representatives who came to see him, I think I'm correct in saying, were AMCU members. And there was, sorry? At least two of them. So there was a sort of an insinuation, perhaps, or suspicion. See, I understand your point that Lonmin didn't have evidence, but if they had a suspicion, albeit an unfounded one, which they believed, then we're not entitled to say that they deliberately spread misinformation. That they spread misinformation appears to be correct, but whether we can be satisfied that they deliberately did that is something which I'd like further argument on if you have it for us, because
Chair,
there's a prima facie I have a difficulty, and you understand it's my duty to put my difficulties to you.
Of course, Chair. The second answer is we deal with this in our heads of argument in some detail. We deal with what we call a campaign of misinformation by Lonmin in detail in our heads of argument. And we draw the inference that because there's absolutely no evidence and none has ever been suggested of either AMCU's involvement or of the cause of the strike being rivalry between the two unions, that the misinformation was deliberate. There's been no answer to those allegations in our heads, either in replying heads from Lonmin or in oral argument. So the allegations we've made in that regard are unanswered by Lonmin. We simply make that point. Then, Chair and Commissioners, Lonmin also spent a great deal of its argument contending that the...
I'm sorry, can I just put a further point to you? It flows from a point made to me by my colleague. The evidence, as far as I recall, seems to indicate that the trouble, if one can call it that, started at Impala. And there certainly was rivalry between NUM and AMCU. NUM was seen to be ineffective and distracted perhaps by other concerns, not pushing the interests of the workers as fully as they should have done. Whether that perception was correct isn't relevant for our purposes. And AMCU was certainly gaining ground there. And then, now, that was known to the people of Lonmin. Now, if you then get a demand for dramatically increased remuneration, and the suspicion is that AMCU got something to do with A, because of what happened at Impala, and B, because of the identity of some, at least, of the people who went to Siemens with Costa, it's not difficult to understand how Lonmin could have come to suspect that what had played out at Impala was being repeated at Lonmin. It was quite clear, I think, that Lonmin was faced with a situation where AMCU was gaining ground. They'd gained ground dramatically at Korea. There's no suggestion that that was going to stop at Korea. That AMCU were gaining ground. NUM were on the retreat. There was obviously a campaign by AMCU, nothing wrong with that, to get a situation where they had majority support and all the benefits that would flow from that. Now, regard being had to those factors, can one say that Lonmin didn't even suspect that there was rivalry between the two unions? Didn't even suspect that the fact that some AMCU people, and they would think, based on what happened elsewhere, that AMCU was actually supporting the demand, possibly even behind it in some way. And that was part of their campaign to show the workers that they were better equipped to represent them. The question I'm asking you is whether one can say that Lonmin didn't honestly believe that, whether it was reasonable, whether they had evidence to support the suspicion. Those are different questions. But
well,
you
Chair,
see, you've made quite a serious allegation against Lonmin that they came up with these incorrect statements, knowing them to be false. And that's the point I'm putting to you.
Chair, I mean,
before you answer that question,
yes.
can I just add to that? Isn't there evidence that the inter-union rivalry was very marked after the dismissal and re-employment of thousands of employees? Isn't that where, yes, at Korea?
Yes. Of course there was union rivalry. We accept that. What we don't accept is that there's any evidence that that was the cause of the strike. And if Lonmin believed that...
I'm sorry, the question doesn't relate to that. With respect...
but I think I'm getting to the answer.
The question he was put, not the question. I'm not being unkind. I mean, I understand. I'm being difficult, really. Moro Mayo. But the point is not whether there was evidence. The question is whether one can find that they A, suspected it, or didn't even suspect it, and B, if we find that they did suspect it, can one say this suspicion was one that they didn't truly hold because there wasn't evidence to back it up? Because suspicion and evidence aren't always the same thing. Very often they are not, as you know.
Well, Chair, they simply haven't explained it. So in the absence of concrete evidence and the absence of any explanation or substantiation by Lonmin of their suspicion, we submit that it's highly questionable.
Did you ever put it to them that you didn't believe that, you didn't even suspect it? Were they ever called upon to answer that question directly?
Well, I did put it to Mr. Marikana that there was no evidence and there could be no suggestion that the strike was caused by union rivalry. And his answer, we refer to it in our heads of argument, was rather lamely to say, well, the two union presidents during that week didn't seem particularly fond of each other. I mean, so that's the extent of the evidence of why.
That wasn't a very good answer.
That's the extent of the explanation for their suspicion. We submit that there is none. What one also sees, Chair and Commissioners, is that Lonmin, in fact, they in fact attributed much of the violence and even deaths to union rivalry. I mean, we see that in media statements that they issued. That information was then obviously handed over to the police, so that we see the same thing in Exhibit L. We've referred to that in some detail in our heads of argument. One also sees in a speech given by Mr. Farmer that he in fact attributes the 34 deaths on the 16th of August 2012 to union rivalry in a speech that he gave on just before his resignation. We submit that there's no basis for that. Can I move on to my next point? So the next point we want to make deals with the contention by Lonmin that the demand was non-negotiable. And there we just want to make the point that Lonmin haven't dealt at all with Mr. Mthunjwa's uncontested evidence that when he spoke to the strikers on the 16th of August, they in fact said to him, and if I can quote, they were aware that management might not have 12,500 from the start, but that perhaps such a position could be achieved through a process and over some time. So that's in Mr. Mthunjwa's statement. He repeated it in his evidence here. And of course, that's the feedback, that it was part of the feedback, a crucial part of the feedback we would submit, that he wanted to give to Lonmin on the 16th, but they refused to speak to him.
I'm sorry, I didn't want to give the impression of heckling you, but when you raise points and I think of possible answers, it's my duty to put them to you. There are two aspects of this matter we've got to look at. The one is, using hindsight, can we say that it would have made a difference? Or were they resolutely determined to get 12,500 and not a cent less? The answer, if that's the contention put up, you've got the answer for what Mr. Mthunjwa said. But the other aspect we have to look at is whether Lonmin thought at the time there's no point in negotiating because they've drawn a line in the sand and that's it. Now, admittedly, the evidence they rely on isn't also terribly helpful as direct evidence of that, because they also deal with people like Mr. Nzuza and Mr. Mugudwana, what they've said, which, of course, they didn't know at the time what they were going to say before this commission. But in regard, if you're criticising them for not negotiating, and part of your criticism is that they should have realised that they wouldn't have to come up with 12,500 immediately. There was a chance that the strikers would settle for less. Then we have to look at... But on the other hand, they say, what was the point of negotiating? It would have been an exercise in futility because they were resolute 12,500 or nothing, and they couldn't come up with 12,500. That's part of their answer. So one has to look at it from that point of view as well if one wants to evaluate the answer they put up. Isn't that correct? the answer to the correct one is yes, it has to look at it. What the answer is to the further questions is something you'll deal with, I take it.
Yes, Chair. We simply want to make the point that whatever the strikers' position may have been before the 16th, it's not entirely clear in our submission from the evidence. But even if it was, for the sake of argument, resolute before then at the very least it had softened by the 16th. And that was an opportunity for a further opportunity for engagement.
Somebody, I think it may have been Mr. Ramaphosa, but somebody certainly said that experience shows that in industrial negotiations, strikes and things of that sort, strikers always draw a line in, or pretend to draw a line in the sand, but the problem is normally solved somewhere east or west of the line, and not on the line.
It's certainly
Was that Mr. Ramaphosa who said that? Someone said that.
It may have been. It was certainly not a reason not to negotiate in our submission.
Ms. Bonds, it's now 10:30. When it's convenient for you, would you let me know, and we'll take the adjournment?
This is a convenient time, Chair. Thanks.
15 minutes.
I'll just put it in with my last bit. Was it okay? I don't seem to take me too much on that. That's what you must have done, which is good, right? Leave that hanging. You seem to be suggesting that Joseph
Commission resumes. Ms. Barnes.
Yes, thank you, Chair. If I might then make my final point, and this relates to, I'd just like to elaborate on the basis on which we say that Lonmin there may be criminal liability for Lonmin on an accomplice basis. We say in our heads of argument that Lonmin colluded with the police to break the strike, and we don't use that term lightly. We don't use the term colluded lightly. It is considered. It means to come to a secret understanding for a harmful purpose. We submit that if one looks at the transcript of the meeting between General Mbombo and Mr. Mokoena, what you see there are three things. First of all, you see an agreement that a hard line is going to be taken in relation to the strikers. And Mr. Mokoena conceded this in answer to questions from Mr. Chaskelson. So it was agreed between the two that a hard line would be taken. In other words, there would be no negotiation with the strikers. The second thing one sees is that a police operation will be launched. It's a question of when. At that stage, it was due to be launched on the Wednesday. And the third thing one sees is that despite that those two things are agreed upon, essentially, despite the fact that it is foreseen that there may be bloodshed. It's clear. General Mbombo says so in terms. So we submit then, even if the term collusion is perhaps overstating the position, we submit it's not. If one looks at the transcript and one looks at those three key issues upon which agreement is reached, then in any event, we submit that if one were to use the term cooperation instead of collusion, one would still have a basis for accomplice liability. It's clear that SAPS and Lonmin cooperated with a view to launching the police operation, and it's clear that they did so despite foreseeing that harm may result. And this is critical. So we know that both General Mbombo and General Mpembe foresaw harm and indeed bloodshed, and communicated this in the meetings to Mr. Mokoena and the other Lonmin persons who were present. But what's also important to stress is that Mr. Jamison himself foresaw injury and possibly death arising as a result of the police operation. And we refer to the passage. We refer to the evidence in that regard at page 183 of our heads of argument, where it of course arises out of Mr. Jamison's email, and this is as early as Tuesday, the 14th of August 2012, where he says, although we are glad about the police operation, there's always the worry that it goes wrong. And then he's cross-examined on that, and it's put to him that based on that he foresaw the possibility that something could go wrong and that there might be injuries and possibly even deaths as a consequence of the police operation. And he says, you've got it, I'm just going reading.
The passage is quoted to page 183 of your
Yes.
where Mr. Jamison says, Mr. Gott puts to him the quotation, although we were glad about the peace operation, there is always the worry that it goes wrong. I asked him about that, and then he suggests that they foresaw something going wrong and injuries and possibly death. Jamison says, yes, well, what Mark had said on the phone was, we have to be worried here that this is, maybe 2,000 or 3,000 people who are armed. We've got a lot of police on site who are also armed. And whilst there's a plan in place that the police have, which is the police's call, it's not ours, that sounds like a situation where things might go wrong, where you've got an angry group of people who are armed, and one other group of people are intent on taking the arms off them. It's clearly a situation that has the potential to go wrong, but you would think that the police had covered those eventualities. Now, the plan that's being talked about is the encirclement plan, because that's clear from what the provincial commissioner said. He discussed the plan. You remember they used the wrong word in the original transcript, but it's encircle is agreed now to be the correct term. But there was also the letter that Mr. Ramaphosa got from the representative of his company on the executive, where she spoke about the police having I think she used the word corral, if I remember correctly, but certainly she was clearly talking about the same plan. So what the Lonmin people knew about was a plan, which was the so-called encirclement plan, which was designed by the police to be as, I think I'm accurately summarizing the evidence, to be as risk-free as it was possible in the circumstances. They certainly don't appear to have had any inkling that that plan would be abandoned because it couldn't be implemented because of a decision made on the Wednesday night, and that another plan has to be knocked together in a hurry on the Thursday to replace it with all the problems that poor Scott had, because he sat there in the morning. He was according to the minutes of the 6:30 meeting, which admittedly were edited at Roots, but there's no reason I would think to disbelieve this entry, that he was called upon to draw a contingency plan if they didn't lay down their arms, which of course indicates that the plan they already had couldn't be used, and they knew that. And he was able to attend to the matter after 20 past 8, because that's when he'd finished helping with the coordinate search application. And he sat there from 20 past 8 through until about 1 o'clock. And we know how he works. He prepares documents, and he sets out things on his computer and has them printed and hard copies to everybody. But he didn't do that. And when he was asked to explain why he didn't do it, he said he couldn't remember what happened that morning. Well, it doesn't require too much insight to understand what inference one draws from that. So he was, and he conceded that in his evidence later, that he had a very difficult task to do, a very difficult plan to draw up, and created by this deadline that had come from above, which they couldn't do anything about. But the reason I put all that to you is there's no reason for the Lonmin people to realize that that would happen. And could it ever have been, let me put it this way. You understand this is just a prima facie point I'm putting to get your assistance. But was it reasonably foreseeable on the part of the Lonmin people that the police would impose a deadline the night before without even knowing what the details of the plan were, whether the plan that was ready could be implemented on the Thursday, in the circumstances which they knew about, and that in the result the police would have to knock together a plan with all the defects to which the evidence leaders have referred on the Thursday? Was it something that one can say that the Lonmin people should have reasonably foreseen that sort of thing might happen?
Chair, no, not that they would have reasonably have foreseen what happened with regard to the NMF meeting. Certainly not. But can I give two answers? The first is that it's...
Sorry, before you answer, just to finish, you remember what I put to was it appears from the evidence that Lonmin knew about the first plan. They knew, not necessarily the details, but they knew there was a plan that had been worked out. This corralling plan, I think, is the way how it was described in the email that Mr. Ramaphosa got. It's the encirclement plan. So they knew the details of that. If that was a relatively risk-free plan, then Lonmin would have known that as well, I take it. It's a fair inference. The question is whether they could reasonably foreseen that relatively risk-free plan would be abandoned and replaced by something cobbled together at the last minute that was certainly would be the argument with a very, very risky plan.
Chair, the difficulty is if one looks at this passage, if one looks at Mr. Jamison's answer here, it certainly doesn't appear as though he's aware of some sort of risk-free encirclement plan, because he refers specifically to 2,000 to 3,000 people who are armed. I mean, his answer here seems to suggest that he envisaged something in the nature of what did actually happen. The first answer is it can't be said from his answer here that we don't know exactly what Lonmin knew about the plan and what detail they knew, but it can't be said from this that he was aware that a safe encirclement plan or some sort of rational plan that was safe was envisaged.
Yes,
but
yes, you're correct, but he does say, in fact, appears not to have known the detail, because he ends up by saying you would think that the police had covered those eventualities.
But, Chair, the fundamental point we submit is that both General Mpembe and General Mbombo said there may well be blood. You need to talk. That's what Mpembe said on Wednesday afternoon. You need to talk, otherwise there may be blood. And Mbombo said the same thing to Mr. Mokoena on Tuesday, and Lonmin still refused to talk. So they must have been aware, with respect that the police operation, the details of which they couldn't have been certain of, carried a risk of bloodshed. The two generals told them that.
Well, Mpembe's statement Mpembe's statement you rely on, made to Zakwana, was made in the context of not implementing the encirclement plan, but talking about disarming a man on the koppie with an axe, who's armed with an axe, and you've got a rifle. But certainly, the passage in the transcript of the conversation between General Mbombo and Mr. Mokoena does appear to support you.
I'm really referring to the transcript of the meeting that was held on Wednesday afternoon that General Mpembe chaired. And there's, in fact, I think the appropriate or the applicable passage is, in fact, in our heads. I'll find it in a moment, where he specifically he calls upon the parties to talk in order to avoid further bloodshed. So it must have been clear that if the matter couldn't be resolved through negotiations and if a police operation had to be resorted to, there was a risk of bloodshed. I'll find that passage in a moment, Chair. But if I might then just make a point about Mr. Ramaphosa's involvement and indicate what our position is on this. Chair, what we say here is that it's not really the fact of communicating that is objectionable, but it's what was said in the communications. And what we'd like to highlight is two things. First of all, Lonmin witnesses conceded that by Tuesday, the 14th of August, the big police presence at Lonmin that they had sought had been achieved. And we know that that's objectively true. So that had been achieved by Tuesday. The situation had effectively been brought under control by Tuesday. And then on Wednesday, you have Mr. Ramaphosa saying in an email that it's important, and he's going to get Minister Mthethwa, the Minister of Police at the time, to act in a more pointed way. And Chair, that's what we submit is disturbing and questionable, because you had a situation where you had, Mr. Ramaphosa's explanation for his requests was that he wanted that he sought, for the criminal elements to be arrested and dealt with, and for the police to take control of the situation. But that had happened.
Well, it's not entirely accurate, because when in the face of that big police presence, you still had Mr. Twala being killed. Now, it's probably a fair inference, even without having regard to what Mr. X said, that Mr. Twala was killed because he was suspected of being a police informer. And there may well have been, again, we've got no basis for saying this is correct or incorrect, but it's probably a fair assumption that there might have been a few more informers on the copy. These people from whom the police handlers were getting their information. So there was still an ongoing possibility that even if the strikers weren't killing other people, there might have been further Twala-type deaths from after the Tuesday. Isn't that correct?
Chair, yes, but it's difficult to understand what acting in a more pointed way could have referred to, given that there was now a big police presence, the situation had been brought under control as far as it could. So we submit that the use of that term in that context is highly questionable. That's as far as we take it. But for that reason, we say that Mr. Ramaphosa should be included in the list of people that are investigated in relation to this issue. And we'd like to say in conclusion that we support what the Legal Resources Centre has said on this issue. We align ourselves with their submissions. And we refer specifically to page 174 and 175 of their heads, where they list the Lonmin executives that they say should be investigated in this regard. We would add Mr. Ramaphosa to that list for the reasons I've given. And then, of course, they also indicate that Lonmin itself as a company could be investigated on the same basis at page 175, and we align ourselves with that recommendation as well.
But taking your argument just from this answer from Mr. Jameson. Lonmin being aware of all the risks involved, but wouldn't you think that in view of what he says here, that you would think that the police had covered those eventualities? On what basis can you say now they foresaw death? When they say, much as we know about that, but then the police had a plan. So in that plan, we assume that they are going to cater and make sure that those eventualities of death do not occur. What else could Lonmin do then?
Commissioner Takota, I think the answer is then one would have expected Mr. Jamison to have answered, no, not at all. We did not think in our wildest dreams that the police plan could go wrong. We thought that they'd have it perfectly under control, and we didn't think that there'd be any injuries, let alone deaths. But he doesn't say that. No.
Isn't that what he's saying here?
With respect, no. He says there is this kind of plan with 3,000 armed people on a kopie who don't want to be disarmed, and the police trying to disarm them has the potential to go wrong. So he does foresee the risk of something going wrong in our submission.
Mr. Ramaphosa was questioned quite a lot about the more pointed way. You think we should reject his explanation to that?
Commissioner Takota, we submit that his explanation is difficult to understand in relation to the timing of the more pointed way, and for that reason we say it's questionable. And his explanation is unsatisfactory because of when he said it. If he'd used the same words a few days earlier, the situation might be different. But he was asking for additional, more pointed action at a time when the situation had been brought under control. And that we submit as worrying.
Yeah, but the incident of death occurred on Thursday. Would you say he had foreseen that in the light of the fact that he was arranging a meeting for a Friday?
Chair, we simply say that he should be investigated together with the other Lonmin executives on this issue, because he did, of course, act in his capacity as a Lonmin director. If I might just refer finally, Chair and Commissioners, to it's on page 46 of our heads, and this is the meeting with General Mpembe, I beg your pardon, that I was referring to, and he says inter alia the following: "We are now faced with a situation where we don't want to be seen as the police that is brutally killing people." And then it goes on: "We are policing in a democracy where negotiation is a weapon, not the bloodshed. My request is one: we need both your intervention. The operation has reached to a sensitive stage, and we might go and lose more lives." So in other words, he is saying there's a risk of lives being lost, there's a risk of further bloodshed if you don't intervene and try and achieve a negotiated solution. Thank you, Chair and Commissioners. Those are my submissions.
Thank you, Ms. Barnes. Mr. Gotts.
Chair, thank you, and good morning to you and the Commissioners. Chair and Commissioners, it's fallen to me to deal with two outstanding issues which we address at some length in our heads of argument. And those issues are, as my learned friend Ms. Barnes indicated, the issue of the NUM and our submissions in relation to that. And in addition, the issues relating to the police action, particularly at Scene 1, on the 16th of August 2012. And I'd like to present my submissions under four themes. The first theme is what we refer to as NUM's responsibility during the week of the 9th to the 16th of August. And what I'd like to address there is the allegation that I beg your pardon, 9 to 16 August 2012. And what I'd like to address there is the question of whether or not NUM can be considered to be blameless, as it were, because of the fact that there was no mandate that it had as a union to take up the RDO's issue. The second theme that I'd like to address are particular issues relating to the 11th of August. Very little airtime has been given to those events during the proceedings thus far, and I fear with respect there are certain issues that need to be, or facts that need to be corrected in relation to the events of the 11th of August. And what I'm referring to there in particular is what happens when the crowd of strikers reaches the NUM office and there's the shooting by the NUM officials. My third theme, as I've indicated, is turning to SAPS and its conduct, particularly in relation to the 16th of August. And my fourth theme is really to sweep up a couple of additional residual issues, and I'd like to deal with two matters there. One is a submission by NUM in relation to the policy of centralized bargaining, and the final issue is, again, a submission by NUM in relation to how one must view the composition of the strikers on the 16th of August at the Kopi. Can I preface my remarks and my address by making this point? A lot of what I'm going to say may be regarded as being quite critical of NUM, and I want to emphasize that in doing so, it shouldn't be regarded in any way as some form of inter-union rivalry between AMCU and NUM. The submissions are being made simply because of the fact that we believe that NUM's responsibility, particularly in relation to issues just prior to when the strike started, and also its conduct on the 11th of August, were major factors which influenced the developments subsequently during that week. And we believe not through any sort of contestation between AMCU and NUM, function of contestation between AMCU and NUM. There are issues that need to be ventilated, and it's simply that we've chosen to do so in our heads of argument and our address. There's a large section of NUM's heads of argument, so let me turn to the first theme that I'm going to address. There's a large section of NUM's heads of argument which are devoted to an attempt to say that it should bear no responsibility because of the fact that it had no mandate from its members to take from any RDO to take up the issue that the RDOs were raising, being a demand for 12,500 Rand. And the logic of the argument, and one sees this both in NUM's heads of argument as well as the evidence leaders' argument, is that because of the fact that the workers at an early stage had rejected NUM's involvement in the raising of the demand, and in those circumstances NUM had no mandate to take the demand up, this meant that NUM was effectively entitled to remain completely uninvolved and must be found by this commission to be, as it were, blameless for the subsequent events. Chair, with respect to the evidence leaders and my learned friends for the NUM, we do not agree that NUM cannot be faulted because it had no mandate from the RDOs. And we respectfully submit that, in fact, a large portion of the responsibility for what happened must be attributed to the fact that NUM took an incorrect and largely indefensible position in key meetings just prior to the commencement of the strike. And may I refer the commissioners in that regard to page 112 of our heads of argument, where we cite a witness statement, a paragraph in the witness statement of Mr. Setelele, which is Exhibit YY1, paragraph 4. What Mr. Setelele says and I'd like to emphasize certain portions of this paragraph, is that the issue of this demand by the RDOs was discussed at various meetings by the NUM branches in Lonmin. And NUM's position was consistently put forward in these meetings, namely that the wages of the RDOs was covered in the 2-year collective agreement that had been concluded, that it was a breach of this agreement for the RDOs to raise fresh demands during the term of that agreement, and NUM was opposed to an unprotected strike. Now, Commissioners, during the course of Mr. Setelele's cross-examination, the chairperson established through his own cross-examination very effectively 2 fundamental points.
Mr. Gotts, I was going to get some praise from Mr. Rampele, but I didn't get it because I pulled him up. But I didn't expect you to criticize me the way you're doing. I suppose it looks like cross-examination. I suppose I must plead guilty. I'm not supposed to cross-examine witnesses, am I?
I beg your pardon. My choice of the words cross-examination was incorrect.
With such
Questioning
fortitude as I can muster.
Questioning would be. I do beg your pardon, Chair. Through your questions, Chair, 2 facts were established. The first is that Mr. Setelele had consistently articulated this position at key meetings, inter alia at the meeting of the NUM members on the afternoon of the 8th of August 2012, the day before, or 2 days before the strike commenced. And the other fact that emerged during the course of the chair's questioning was that Mr. Setelele accepted that this position, in other words, that it was a breach of the agreement for RDOs to raise fresh wage demands during the term of the agreement, was a fundamentally incorrect one. And the reason for that, of course, was that the 2-year wage agreement could be varied by agreement.
I don't see you quoting the relevant passage in your head at this point, and maybe you do elsewhere. But the passage in the head said that every demand that was raised that's not dealt with in the agreement is regarded as having been settled. And it then went on to say that, accordingly, it's not possible for the employees to engage in strike action in support of such demands. But it was made quite clear by Mr. Sekwana, not that, with respect, we needed his assistance, but in fact it was welcome all the same, that that didn't prevent the union from going back to the employer and saying, look here, we know we can't strike, but we have got the right to engage you on the matter. The agreement can even be amended. There have been precedents in the past where points of that kind arose. There was a dramatic increase on one occasion in the inflation rate, and the inflationary increase was way out of line with the actual inflation. The union went back to the employer, and the employer accepted the point was a good sound one and amended the agreement. So there was no reason why NUM couldn't have gone to the Lonmin and said, look here, we know you were banned, you wouldn't accept the RDO's demands at the time, but things have changed. Look what happened in Apollo, look what happened in Amplat.
Yes, yes, indeed,
and
Chair.
And the fact, this is something I should have to put to Mr. Tip, but it's not entirely realistic to say they didn't raise it because they didn't have a mandate. If they'd realised that it wouldn't be a breach of the agreement, if they'd also realised that they had the monopoly of bargaining rights in respect of negotiating rights and so forth, in respect of the emolument to the employees, they could well have gone back to the employees and said, look here, we can't strike because of this, but what we can do is we can engage Lonmin, and please give us a mandate to do that, and we will raise the matter on your behalf. They didn't do that, and the impression I get, Mr. Tip will tell me why I'm wrong if I am wrong in due course, but the impression I get is the reason they didn't seek a mandate was because they didn't think that it was open to them to approach Lonmin because they'd misinterpreted or forgotten the relevant clause of the agreement.
Yes, indeed, Chair, and that is essentially our submission, and you've summarised it extremely effectively, and I won't pursue the argument in the sense that I don't need to persuade you. You've appreciated the argument. The relevant references, Chair, for Mr. Zekwana's statement that that miners were aware that changes could be made to the to the agreement, that can be found on day 46, page 5027 of the transcript, and it's lines 10 to 23. And an easy reference for this is also Num's heads of argument at paragraph 157.
What page are you on?
Sorry, Chair, I'm giving you the references for
Yes,
the point that you made about Sequana. I'm not sure that they are in our heads.
I think Mr. Num gives. Sorry, Mr. Tip gives them, behalf of his client Num. I want to say that your heads, I must say, I found very helpful. They've addressed most of the pertinent passages in the record for us. Regard being had to the fact that there are going to be something like 40,000 pages at the end, any help in the labyrinth that we get from Council is gratefully received. And certainly you've given us a lot of help, for which it's appropriate for me to thank you.
Thank you, Chair. Chair, and just to emphasize the point that Num, of course, was at the time fully aware of the fact that the RDOs were underpaid. And indeed, at the conclusion of the 2011 wage negotiations, was so concerned about the failure to achieve a differential increase for the Lonmin RDOs that it warned that the situation was a ticking time bomb. That factor, coupled with the fact that the wage agreement could, in these sort of circumstances, be varied by agreement, we submit those are two undisputed facts which must be seen in or must form the backdrop of evaluating the impact of Num's position that the agreement could not in fact be varied. In fact, it would be a breach of the agreement in order to do so. And we submit in those circumstances that the attempt to suggest that it bears no responsibility for the subsequent events because it did not bear a mandate or did not have a mandate from the RDOs should not be accepted. And we submit that the...
Yes, I understand that. I understand that submission. We'll get comment from a slightly different angle from Mr. Tip on it in due course. But what kind of responsibility are you talking about? I understand the submission. They must bear some responsibility for what happened because of what they did and particularly what they didn't do. But how would you describe that responsibility, and how would we, if we accept your submission, how should we describe the responsibility in our report?
Chair, may I make the submission? We would say that a finding that the NUM officials who articulated that position improperly and possibly negligently articulated that position, which had the effect of foreclosing any prospect that the demand of the RDOs would be taken up by the NUM. And with this constitution...
further than that, by the only union which had negotiating rights in respect of increases of emolument.
Indeed.
Because of the structure of the agreement between, or the content of the agreement between NUM and Lonmin.
Indeed.
NUM had a monopoly from the employee side of negotiating rights, and if they didn't choose to exercise them, there was no one who had the power under the various collective agreements to do that. Isn't that right? So I'm sorry, that takes the submission further than you want to take it.
No,
prima facie seems to be correct.
Indeed, Chair. And what we say is that indeed created a responsibility not only to its own members, but of course to all of the RDOs at Lonmin, because it alone had the right to bargain on their behalf, and of course AMCU did not have the bargaining rights. And Chair, in addition,
not only that, even the non-unionized workers didn't have those rights either, isn't that so?
Indeed. And we would say finally that this constituted a failure to properly represent the interests of the RDOs in circumstances where they knew that the situation was a ticking time bomb. Now, Chair, that finding...
So all you're asking us effectively to do is to make that finding. That would be a...
That was the preface to my next submission.
I'm sorry, forgive me.
Chair, under the terms of reference, you're required, the Commission is required to consider inter alia whether NUM used its best endeavours to resolve the situation. And we would submit that this does, on our submission, fall under the rubric of that term of reference. And you can make a finding in terms of the terms of reference that by virtue of this fact alone, NUM did not use its best endeavours. My learned friend, Mr. Berger, yesterday used the example of the counterfactual, which he indicated was a term common to the competition regime. And essentially the inquiry is, but for a particular fact, would the situation have developed differently? And we submit under this counterfactual, a counterfactual in which NUM had recognized what its responsibilities were to the workers and indeed adopted a position which was not the one that is as articulated by Mr. Setelele. Things may well have developed differently, and you can find that on a balance of probabilities. Chair, we do not make the submission that leads to any form of delictual or criminal responsibility on the part of NUM. It's simply a submission that, under the terms of reference, it must bear the responsibility for its failure to properly represent the RDOs under those circumstances. Chair, may then I turn to
Sorry, Mr. Gotts. Do I understand? I just want to clear up my mind. Do I understand you to be saying that NUM should have taken it upon itself to do the negotiations on behalf of the RDOs for this 12,500?
Chair, I put it, sorry, Mr. Tukorta, I put it no, Commissioner Tukorta, I put it no higher than this. If NUM had not articulated this position at a meeting and instead adopted the position which we submitted ought to, that these were extraordinary circumstances prior to the strike having started, in which RDOs were underpaid, and in circumstances where they had been told expressly that the RDOs were heading for an unprotected strike. What it ought to have done under those circumstances was said to the RDOs, but we can, in fact, take your cause up and have a variation, possibly a negotiation with Lonmin, with a view to varying the 2-year wage agreement. And its failure to do that, it's principled
Mr. Gotts,
and
I'm sorry, it's not as simple as that. NUM have said, and I think it's quite clear from the evidence, that they only act on mandates from their members. So you would have to go further with the submission. I'm not saying it would necessarily be a wrong submission if you went that far, but anyway, we're just testing the argument at the moment. That surely, if there's any merit in that submission, you would have to go so far as to say that NUM should then have approached the RDOs and said, look, we've got the monopoly of bargaining rights. We are prepared to take this up if you give us a mandate to do so. And if the RDO said, no, we're not prepared, we're not prepared to give you any mandate to do anything, then of course the situation might be different. But I don't think it would be valid criticism of NUM. Again, this is all prima facie, I haven't made up my mind anything. It wouldn't be valid criticism of NUM to say that even without a mandate, without even seeking a mandate, they should have gone off to Lonmin to raise the situation of the RDO.
Indeed, Chair, I think that's absolutely correct. It had the opportunity to facilitate that. There were various meetings by Mr. Setelele's own admission that the demand by the RDOs in that paragraph on screen was discussed at various meetings by the NUM branches. So it was a topic for discussion, yet it did nothing to facilitate the obtaining of nothing to facilitate obtaining a mandate from the RDOs.
To be fair, the problem appears to be that they misunderstood or misinterpreted the terms of the agreement. So they thought the door was closed. They thought there's nothing they could do. That's why they said to people, no, we can do. We must wait till the agreement expires and take it up again then. So their mistake or failure or omission or whatever the appropriate word is was apparently brought about by a failure to interpret their agreement correctly. That would be correct, I think.
Yes, Chair, with this gloss, I would with respect submit that misunderstanding was a negligent one. In circumstances where even Mr. Zakwana says that the NUM officials and indeed the NUM membership is aware that these agreements can be varied and indeed have been varied in the past. The position that Mr. Sitalele says was articulated and taken by the NUM officials at Lonmin, mistaken as it may be, was nevertheless a one that was born of negligence, if not gross negligence, with respect, Chair. Chair, may I then turn to my second theme, which is a range of submissions in relation to the 11th of August. And there are really 4 topics under that theme. The first topic that I want to address briefly is the issue of the time of the incident. The chairperson, during a debate with my learned friend Ms. Pillay on the first day of argument, asked Ms. Pillay, are we certain of the time in which the attack at the NUM offices occurred? And Ms. Pillay said that she would revert after the break, and then did revert with the information that Mr. Motlechelo had indicated in his witness statement that the march had occurred march had started towards the NUM offices at 11 o'clock on Saturday morning. Chair, there is in fact a considerable amount of objective evidence which I'd like you to refer the commissioners to, which in fact indicates that the march occurred much earlier and indeed before 9 a.m. And I'd like to refer the commission to those pieces of evidence. There are really 5 pieces of evidence. But before I refer you, I think it is important for me to indicate that we are, on this score at least, at idem with NUM. Because in NUM's heads of arguments, in paragraphs 234 and 235 of their main submissions, referring to an entry for 903 in the Lonmin logbook, which is quadruple E19A, exhibit quadruple E19A, Lonmin's counsel say that entry for 903 plainly relates to a situation after the attack had been dispersed, at a time when the 2 injured strikers were being removed to hospital. And let me indicate again that that is in relation to an entry for 0903 on the morning of the 11th of August. So the first piece of evidence is indeed the Lonmin logbook, which has a variety of entries which indicate that the attack or the incident occurred prior to 9 a.m. On the 11th of August, on exhibit quadruple E19A, there's an entry for 9 a.m. which says that France Mabeleni reports a person shot at Wonderkorp Hostel. There's an entry for 0908 which says that France reports a person being shot inside the hostel next to the Shagan offices. And then there's an entry for 0936 which talks about medics transporting one patient to the Andrew Safi hospital with one gunshot wound in the lower back. And those entries, Chair, undoubtedly relate to the times when Lonmin security personnel found the 2 victims of the NUM shooting. And as I've indicated, those bodies or those people were found at 9 a.m. and 0908 respectively.
It's in the occurrence book.
In the Lonmin logbook, yes. In the Lonmin logbook.
It's Lonmin occurrence.
Now, Chair, although
it occurs to me, can I just put something to it?
Yes.
It occurs to me that it was a point put to me by one of the evidence leaders after we adjourned when I raised the point, to say that if we get the vehicle, I forget the abbreviation, but there's AVL. That's right. We get the AVLs of the document of the vehicle that the Lonmin security people were travelling in on the morning of the 11th, we will get, one hopes, accurate evidence of when this incident, when they went to the NUM office. And we won't then be dependent upon the accuracy or otherwise of someone who is making entries in the Lonmin occurrence book. And if this point is important, as I think it probably is, I'm sure if we ask Lonmin to give us those records, they will do so without any inappropriate deletions. So perhaps we could ask them now, Mr. Bam, you're following the point. It shouldn't be too difficult for your clients to give us the AVL records relating to the vehicle driven by two Lonmin security officials who went to the NUM office on the morning of the 11th of August, apparently to warn the NUM people of the information that they'd received to the effect there was going to be an attack. Mr. Bam is making a note and nodding his head. So I'm not going to stop him arguing, but it seems to me that that might be a satisfactory way of resolving the problem.
Yes, Chair.
It may well be this information will be entirely in accordance with your submission.
Indeed, Chair. Might I mention that what I'm dealing with is the objective evidence which supports the proposition that it happened before 9 a.m. And this is the first of 5 pieces of evidence that I will refer to.
This evidence all subject to the possible problem that they were entries made in the Lonmin occurrence book after the event at the time was incorrectly recorded. It may be correctly recorded, but there's a problem. But the AVL records will indicate, one hopes with greater accuracy. You see, one of the problems is Mr. Mabu Yakulu, in a passage of the evidence which you quote at top page 123, says, on the 11th at 9 o'clock, we met at Vonnegut and we exchanged views. It was then decided that we should approach. So there is evidence the other way, apart from the evidence leaders refer to. There is evidence the other way, that the approach to the office was followed on a meeting at Vonnegut, I think it would be the stadium, where the matter was discussed. So there's evidence on either side of the line, but hopefully the AVL material, which Mr. Bam is going to get us, will put the matter beyond dispute.
Indeed, Chair. May I mention the other evidence? It's evidence which is outside of the Lonmin logbook, which I think is, in addition, we would get the AVL, which would records which would confirm the submissions that we are making. The other evidence is, just briefly, Chair, because I'm running out of time, it's the dockets in relation to the finding of the body of Mr. Maibukulu and Mr. Ngema, both of whom were shot, contain statements by the police officers that they received the relevant call to come to the scene at 9 a.m. And in both of those dockets, that record statements of the bodies of Mr. Mabuyakulu and Mr. Ngema, who are, of course, still alive at the time, having been found at 9:15 and 9:20, respectively. That is a piece of evidence that is quite independent of the Lonmin logbook, because those police officers responding to the call would not have any influence or not be influenced by the Lonmin logbook. Mr. Setelele's witness statements, you will recall he testified that when the two Lonmin security personnel, Mr. Marikana and Motlokhela, arrived on the scene, he then left to take the quantum vehicle away to a point of safety. He says in his witness statement that those two security guards arrived at the NUM offices at 8:30 a.m. Chair, then in addition, there is indications that senior SAPS members were told, probably by Lonmin or perhaps by the officers involved, that the incident had in fact occurred at 8:30. You'll recall, Chair, that that Brigadier Karlitz testified that when he arrived, he received an email which he then forwarded on to the Nat Jock, which had described the situation at the time. And in paragraph 27 of his witness statement, he quotes that email which he forwarded on, and he records that the incident occurred at 8:30 a.m. in that witness in his witness statement. And then finally, Chair, there's the objective evidence of the video from camera 218, which is the taxi rank dome camera, which is exhibit X1. And the time on that camera, Chair, records the time as the group of NUM members are seen returning to their offices after the incident. The time is recorded at 09:34, but it's important to note that Mr. Dirk Boertes gave evidence that he had checked the variances between the times of the various CCTV cameras and had found that the variance between camera 218 and actual time was 26 minutes. In other words, that this camera was running 26 minutes ahead of time. So what we can conclude from that is that the time when the NUM officials returned to their offices after the incident was at 9:08. And Chair, that's what we would submit as 5 independent sources of evidence which would corroborate the indications in the Lonmin logbook that the incident actually did take place before 9 a.m., notwithstanding what some of the witnesses that have testified may have put the time at. And Chair, we say that this is a matter of some importance, largely because of the suspicion that the strikers armed themselves inter alia with pangas from Mr. Kassim's shop, which, as you know, only opened at 9 a.m. prior to the march to the NUM offices. And we've submitted in our heads of argument that we've submitted that, in fact, the arming of the strikers with inter alia dangerous weapons such as pangas was, in fact, a response to what they perceived as having been an attack on them as a consequence of the following the march. Chair, let me deal briefly with some of the issues relating to the actual incident. We know from the evidence that approximately 2,000 to 3,000 people marched towards the offices. We know also that there was a rumor that was started, and we've set out in our heads of argument the evidence that this was effectively a rumor. And we make the submission that being a rumor where the source cannot be identified, this commission will be very reluctant to find with certainty that the rumor was in fact true. A rumor was started that they were on their way to the NUM offices with a violent intent, that being to burn the offices down. Chair, what's also clear from the evidence is that upon receiving this information from the Lonmin security guards, the 30 or so NUM officials in the offices armed themselves, I would suggest, to the teeth, including with firearms, at least one firearm, and went outside to confront the strikers. The stated reason for that, Chair, was in order to protect their property. Chair, let me emphasize that, of course, the offices themselves were not owned by the NUM. They were offices that were provided by Lonmin. We do accept, though, that it may have contained contents belonging to NUM, inter alia files, which would obviously be property.
It contained the records of the branch.
Yes, indeed. I think
those records, presumably as part of the ongoing operations of the union, would have been important.
Chair, the essential question is, given the fact that the stated intent was to go out to confront the strikers with a view to protecting the property, what are the legal principles that are at play in these sort of circumstances? And we've referred in our heads of argument, as has our learned friends for NUM, to the Van Wyk case, where it is emphasized that taking action which could potentially lead to the deaths of of other people in defense of property is only justified in very exceptional circumstances. And we've set out the principles. In the Van Wyk case, it was found that those were exceptional circumstances, but inter alia, because of the fact that a clear warning had been given that if the persons who sought to invade the property committed to their intended course, there was a firearm on the other side of the door which could have lethal consequences if they pursued that action. And that establishes the principle, Chair, that in these sort of circumstances, this sort of conduct is exceptional. And at the very least, what one is expected of the person who is acting in defense of the property must take clear steps to indicate that potentially lethal consequences might result. And the Van Wyk case goes as far as to suggest that the invader must be told or informed in some way that there is a lethal weapon in the possession of the party.
And of course, the facts of that case were very special. I'm not sure that the principle you're relying on now is necessarily of general application for every situation. You remember the Van Wyk case was the case of a spring gun. The shopkeeper, troubled with all sorts of with burglaries and so forth, then set up the spring gun in his shop.
Yes.
So if anyone came in, the spring would be activated and the gun would go off. So he had ample time to give a warning. In fact, the suggestion was he did, but problems about the language of the warning and all that you remember. But it may well be that in a situation where there is a sudden attack on someone with a view to destroy his property, that he may be entitled to protect himself, or rather protect his property, without giving a warning if there wasn't reasonable time to do so, if his right to protect the property is one which is sufficiently important to trump the rights of the assailants, potential thieves and robbers. So the passage in Van Wyk's case, which requires an adequate warning, may well be based on the facts of that case, with a spring gun set up long in advance. But of course, I'm not sure we've got to go down that avenue for the purpose of this commission, because as far as I can recall, the evidence was that the relevant shots were fired when the strikers were about 30 meters away from the officers. So they would have had, as I see it, prima facie, against subject to what Mr. Tip's going to say, the NUM people had the opportunity to fire warning shots, one or two. And it may well be that once the strikers had seen that the NUM people weren't going to abandon the office, they were going to stand there and defend it, and they were armed with firearms, or a firearm, they might well have decided that discretion was the better course of valor and to depart. So I'm not sure we've got to go down that route, but what I'm saying to you is the proposition you state here in paragraph 26.8 may not be a statement of general application, but you more or less imply that in the way you phrase that paragraph in your head.
Yes, indeed, Chair. And we would submit that the principle that emerges from the Van Wyk case, that taking action in defense of property, which could potentially lead to loss of life, is only justified in exceptional circumstances, is of general application. And that my learned friends for the NUM have correctly referred to the Walters case, which is a constitutional court judgment, which also makes the point, although en passant, that the Constitution has an impact here, because what one is valuing is two independent rights, and the right to life or the potential loss of life is obviously of far greater significance in the balancing or proportionality inquiry than the person's right to property. And Chair, you are, with respect, absolutely correct that what the evidence indicates. I'd understood from Mr. Mtlo's statement that the distance was in fact 50 meters. But even if it was 30, we would submit that, given the description that Mr. Gegeleza gives to the incident, there was ample time to fire one or two shots into the air and to see what the consequences might be. Chair, may I emphasize this, that it
could also, not only have fired shots, say, look here, if you people come closer and attack our offices, we will fire. So that it wasn't just a situation where shots themselves were all that could have been done by way of a warning. there could have been a shouted warning as well.
Indeed, Chair. And this must, of course, we have also referred in our heads of argument to the evidence that, in fact, what the two Lonmin security guards witnessed was, in their words, NUM officials pouncing on the strikers, coupled with the evidence of Mr. Gegeleza, which we submit as indicative of his state of mind at the relevant time, that he was at that point not quite certain whether a fight would in fact ensue, and we've referred to those passages in our
There's
heads
also an
of
entry
argument.
somewhere which indicates that those Lonmin security officers mightn't have been quite as candid about their own involvement at that stage as one would have hoped. And there's a suggestion that maybe no more than that they may also have been involved in something. But so one has to treat their evidence with a fair degree of caution also. But, anyway, it seems that the essential facts which you require for your argument, I would have thought, capable of being established without going into those other byways and side alleys which might cause difficulty if more closely calibrated factual findings were required.
Yes, indeed, Chair. May I make two final points on this very quickly? It is notable, Chair, that we have to rely on the evidence of Mr. Gegeleza in this regard, who neither pulled the trigger in the circumstances, was in fact some distance away from the person who pulled the trigger, and indeed who testified at the relevant time that he was not certain that a fight would ensue. What we do not have, either in the form of a witness statement and certainly not in the form of oral evidence before the Commission, is evidence from the shooter himself. And that places, with respect, the Commission at a distinct disadvantage. It would have been far more desirable had the person who actually pulled the trigger come to give evidence, or at the very least filed a witness statement. But we do not even know, to the best of my knowledge, who that person was.
Now, we don't know who it was, but there were, you will recall, at the time the evidence was given, apprehension, whether reasonable or not, we don't have to go into, an apprehension that if the identity of the shooter became apparent, either because he gave evidence or a statement was forthcoming, he might have added to the list of those who died in consequence of the Marikana troubles.
Chair, I wasn't involved at that stage and wasn't aware of that, and I do appreciate that that would potentially be an issue. But that those
I
sort of
wouldn't allow the witnesses to mention the person's name. They did know who it was, but I, rightly or wrongly, thought it a matter the police can investigate in due course. I didn't think it would be sensible in the circumstances to insist upon that answer being given. And so that may well be a reason why we haven't got a statement. But the point you make, of course, is correct. That whatever the reason was, the fact that the shooter didn't come forward and explain the circumstances of the shooting does hamper, to some extent, the work of the Commission. But I would have thought that the license submissions you made, we can probably make the findings that have to be made for the present purposes, despite that. But that's a matter we have to look at later.
Indeed, Chair. And the final point is this, is that there is really no dispute that what happened subsequently is that the NUM officials then pursued the fleeing strikers through the gap known as Stop Nonsense. And as Mr. Mabuyukulu says in his evidence, in an uncontested piece of evidence, he was severely assaulted and lost consciousness. And we set out in our heads of argument the authorities which indicate that that sort of subsequent pursuit is not something that can fall under the rubric of self-defense. And that, so at the very least, that subsequent assault is not something which can be the subject of a claim of self-defense. And we've referred to the authorities in our heads of argument. Under those circumstances, Chair, we do submit that there is a prima facie case that the person or persons involved were not acting in private defense, putative or otherwise.
Facie case of what then?
Well, it would be attempted murder, and certainly attempted murder. Certainly, those are the charges on the indicative charges on the docket already. and of course, assault with intent to do grievous bodily harm against Mr. Mabuyukulu. So those are the. We would submit that it is open to the Commission to make the recommendation on the basis that there is a prima facie case of attempted murder and assault.
When it's convenient for you, we'll take the tea adjournment. But I'm in your hands. You indicate when it will be convenient.
Chair, I'm at a point where I want to deal with some residual issues in relation to the 11th, but I'm happy to deal with those after.
15 minutes. Commission resumes. Mr. Gotts.
Thank you, Chair. Chair, just to indicate that I hope to be done in approximately 20 minutes, just for the sake of those people who...
Why are we busy with that? Mr. Nsebeza came to see me. He's really, really worried about the fact that the question of time, what we did was we allocated the whole day to you and the families to divide up among yourselves. And the purpose of the hearing, of course, is for main points to be highlighted and really for questions to be put by the commissioners to council so they can deal with them. That's the purpose of it. The main argument is the written argument, and you've obviously appreciated that. That's why you and indeed the families have submitted very full and helpful arguments. But is concern the part of Mr. Nsebeza that his time has been eaten into, and of course this commission's capacity to sit comes to an end at the end of on Friday. So the reason I raise this is that if necessary, perhaps you must tell me now, but I want to ask Mr. Nsebeza, you've got 20 minutes, you say, that you want. Mr. Nsebeza, do you want me to adjourn at lunchtime until 1:30, at least to give you an extra quarter of an hour?
Anytime I can get anywhere and how, Mr. Chairman, I will be very glad to get.
So we will take the lunch adjournment will be for half an hour. Mr. Gotts, if you can use less than the 20 minutes, because your learned friend, Mr. Nsebeza, has got a time shortage problem, I'm sure he'll appreciate it, and I will too.
Chair, then I will try and short-circuit this. Just to emphasize the point made by my learned friend, Ms. Barnes, at the outset, we have reduced the oral argument to effectively a speaking note, which we will hand up
yes,
to...
No, I was very pleased when I heard that, because that also will help us to use the time properly.
There is one aspect that I must just deal with very briefly in relation to the consequences of the Num shooting on the 11th. We have made the submission in our heads of argument that it was the consequence of that shooting that the strikers began to carry the various weapons that they did. And if we are correct in the timing of when the incident occurred, and of course the timing of when Mr. Kassim's shop opened, that would be a strong pointer to the fact that it was in response to the shooting that the strikers began to carry more dangerous weapons. And Chair, that is significant because we submit that one aspect with respect that has been overlooked is that the law relating to the carrying of dangerous weapons has in fact recently undergone a slight evolution. The Gatherings Act, the Regulation of Gatherings Act, now provides in Section 8.4 that no participant of a gathering may have in his or her possession any dangerous weapon as defined in the Dangerous Weapons Act, and that is made a criminal offence. But that amendment to Section 8, with that provision, Section 8.4 of the Regulations of Gatherings Act, was not in fact in force at the time. At the relevant time, the provision of the Regulations of Gatherings Act read somewhat differently, and I'll read it to the commissioners. It said, participants at a gathering shall abide by any law in respect of the carrying of dangerous weapons. So unlike the current position, which makes it a prohibition, the provision merely said shall abide by any law. And therefore what one needs to do is to look elsewhere to effectively the Dangerous Weapons Act of 1968 in order to determine what the position is. And as we will provide this note for you afterwards, but as we indicate there, in the 1968 Act, the relevant provision says that any person who is in possession of any dangerous weapon commits an offence unless he is able to prove that he at no time had any intention of using such weapon or object for any unlawful purpose. So the effect of the provisions which were in operation at the time of the 9-16 August 2012, was that a defense which is potentially of application is created. And the defense is this, that if the strikers believed that they were under attack and required the weapons for defensive purposes, it's at least arguable that they would be able to prove that they had no intention of using the weapons for any unlawful purpose. And the relevance of the submission, Chair, is that the evidence leaders have recommended that there be a wholesale or recommendation for a wholesale prosecution of all those people who have been can be identified in the videos as carrying a dangerous weapon. And at least with respect, as I read the argument, it's because of an apparent a suggestion apparently that the mere carrying of the weapons might be unlawful. And we refer the commissioners to this perhaps simply as a clarification of a point of law. I might have misread our learned friend's heads of argument for the commissioners, for the heads of argument on behalf of the evidence leaders. But it is an important qualification and something which we submit, if we're correct on the facts, is a defense which is potentially of application and which ought to be at least noted in the final report that is issued by the Commission. Chair, then may I turn to issues relating to SAPS, and here I intend to be relatively brief. We really seek to address one or two contentious issues in relation to what occurred at Scene 1 on the 16th of August 2012. We do say that the facts in relation to Scene 1, the factual, what actually happened, is largely at this point well established, if not common cause. And we in our heads of argument have not sought to refer extensively to the evidence in relation to that issues, but we merely do point out that we align ourselves with the factual submissions that are made in relation to, in the heads of arguments of the families, the South African Human Rights Commission, the injured and arrested persons, and of course the evidence leaders. But there is one aspect where we do part company with the evidence leaders, and that is the issue of whether the alignment of the Inyalas at Scene 1 was the product of intention on the part of any person, or as we understand the evidence leaders to be submitting, it was the unfortunate consequence of disorder in the conduct of SAPS and not as a consequence of any intention. And we do, with respect, disagree with that submission on behalf of the evidence leaders. Can I highlight this point, Chair? The evidence leaders have characterized the argument that is being made on behalf of the families, they don't mention AMCU, but also obviously AMCU, as well as the injured and arrested persons, that the case being put is that there was a deliberate intention on the part of SAPS to direct the strikers towards the TRT to set up a situation where the TRT would appear to have reason to fire at the strikers. Now, with respect, Chair, that's not the argument that is being ventilated, certainly on behalf of AMCU. We do not submit that the strikers were intentionally channeled towards the TRT so that the TRT could open fire and kill them. What we do submit, though, Chair, is that this Commission can find that there was an intention to channel the strikers towards the TRT. That is the first question. Was the channeling of the strikers by the Inyalas intentional or merely an inadvertent effect of perhaps chaos and disorder? And Chair, my learned friend Mr. Chaskelson was asked by Commissioner Hemraj the critical question of who was directing the Inyalas, who was giving the orders to the Inyalas at the relevant time. The answer to that question is it was Brigadier Karlitz, and there are two independent sources of evidence in support of that submission. The first is the evidence of Lieutenant Colonel Scott, who in his witness statement was unequivocal in saying that what he heard on the radio was that Brigadier Carlitz was giving orders. Eventually, he says that those orders were to engage. But in the course of that, he refers to the evidence of, he refers to hearing on the radio Brigadier Carlitz giving an order for the Nyalas to come into some form of formation. And that evidence is then corroborated. Perhaps I can give you the reference for that.
Quoting from paragraph 41.11 of your head,
yes,
page
indeed.
188.
Indeed. And then, of course, Mr. Boertes, when I cross-examined him, gave confirmation of that. I put it to him directly, did you hear Brigadier Carlitz giving orders for the Nyalas to come into formation? And he accepted that he had heard that. His only point of disagreement with Brigadier Carlitz was that he hadn't heard Papa signs being used, but had actually heard Brigadier Carlitz referring to drivers and commanders by name. So both Lieutenant Colonel Scott and Mr. Boertes testified that they heard Brigadier Carlitz giving the orders for the Nyalas to come into some form of formation. And given the timing of when those orders were given, we submit that the conclusion is inescapable that Brigadier Carlitz was at the relevant time directing the Nyalas to move forward and come into a particular formation. And there one has the answer to the question of whether or not the channeling was the product of any form of intention on the part of Brigadier Carlitz. And we submit that the answer must be it was. That must be combined with the evidence that Brigadier Carlitz gave that this was what he referred to as a perfecte block, or perfect block in English. And it was put to him on various occasions, why is this a perfect block? And he tried to explain that. But ultimately, we submit that his evidence that this was a perfect block must stand as a clear indication that he'd set out to accomplish something which he regarded as having been perfectly achieved. And Chair, under those circumstances, the evidence of Brigadier Carlitz coupled with the evidence of Lieutenant Colonel Scott and Boertes must lead you to the conclusion with respect that the channeling of the strikers, or the setting up of the strikers in the formation, was the product of intention on the part of Brigadier Carlitz.
What exactly is he alleged to have said? He could never have said what Scott says in the reported speech. They must move up into some sort of formation. He could never have said, please move up into some sort of formation. What formation, what form of formation did he give orders for? Can
Chair,
we make a finding on that?
Chair, it must be borne in mind that these sort of things are effectively what SAPS does on a day-to-day basis. These sort of things are the product of training exercises. And Nyalas are placed in a particular formation in order to direct protesters in a particular direction. And we illustrated that with reference to the POP training manuals in relation to block. So what we submit is that when Brigadier Carlitz says block, when he gives orders that they must move up into a particular formation, the end result, that crescent that one has seen in various diagrams, the simple submission is that is a product of Brigadier Carlitz directing and ordering the Nyalas to move into that position.
I must confess, I read it the other way, and I had serious concerns about it. I didn't know what the answer is. I thought the order he gave was block, and I couldn't. And if that had been done, and there had been a block, we wouldn't have had the problems we had. And I couldn't understand. I still don't quite understand why there wasn't the Nyalas weren't put in a block formation, which would have prevented the front group of the strikers from advancing to their death.
Well, Chair,
But So I just put that to you so you understand where I'm coming from.
Yes.
I don't know the answer, but my impression was, despite some evidence to the contrary, that the order was form a block, and for some reason they didn't. And I don't understand why they didn't. Maybe there wasn't enough time, or there was chaos and confusion. But it isn't, to me, prima facie at this stage, an unsatisfactory feature of the case that there wasn't a block.
Yes, Chair, you will recall, though, that the POP training manuals indicate that there can be blocks of different types. And we illustrated that with reference to Exhibit KKK 49, I think it is, which is the POP training manual in relation to blocking. And what that training manual reveals is that there can be effectively two different types of blocks. The one is the block that prevents a group of strikers moving through or down a particular path. And the diagrams indicate, with reference to a street, that they are prevented from moving down a street. But there are other forms of blocks, and there are blocks that create a channel or canalize, as the wording which is used in the training manual, which channelize strikers in a particular direction. And we submit that that was the type of block that was put in place. Essentially, Brigadier Carlitz, recognizing that his own POP members were probably inequipped to deal with a group of armed striking workers, decided that the best people to deal with the strikers, to do the dangerous work of arresting them, disarming and arresting them, were the TRT. And so he engineered, quite cleverly we would submit, a block known as, well, as he described it, the perfect block, which had the effect of channeling the strikers down towards the TRT for them to be disarmed by the TRT with the tragic consequences. Chair, we do know that the TRT were the special units that would perform two roles. The one role was to protect the POP in circumstances where something went wrong. But the other role, which was equally important according to the evidence of Lieutenant Colonel Scott, was the responsibility, in his words, to carry out the task of disarming and arresting of belligerent strikers. And he makes that point in his witness statement, H 20, paragraph 8.29. So the role of disarming and arresting, as he put it, belligerent strikers, was always to be done by the TRT. And so it's not a particularly difficult to understand what Brigadier Carlitz was attempting to accomplish by setting up the Inyalas in a particular way which would, first of all, channel them towards the TRT, and then ultimately for the TRT, we would submit in his conception of the implementation of the plan, would effectively then be responsible for the difficult task of the high-risk task of disarming and arresting the strikers. So we do say that the channeling was deliberate. And we really part company with the evidence leaders only on this question. My learned friends have indicated that it was negligent on the part of Brigadier Carlitz to not set up the Inyalas in a manner which would block the strikers in the sense of preventing them from moving through what has been referred to as Channel A and Channel B into the position where they would come into close quarters with the TRT. And of course we agree that at the very least this commission should find that was negligent on the part of an experienced police officer, POP officer in charge of those Inyalas. We would absolutely agree. But we would say we would take it a step further and say that the channeling of the strikers in that direction was the product of intention on the part of Brigadier Carlitz. And Chair, just one final point on this in relation to the evidence leaders, and I do make this point with some respect, is that one of the oddities of the evidence leaders' approach in this case is that in relation to scene 2, they, with respect, have no difficulty ascribing the injuries and the deaths that occurred at scene 2 to what they refer to as a paramilitary operation with the aim of annihilating those who were perceived as the enemy. And Chair, we do say, if one is making those sort of comments in relation to scene 2, it is not particularly difficult to come to the same conclusion in relation to scene 1. Why is it a paramilitary operation with the aim of annihilating those who were perceived as the enemy at scene 2? But one cannot ascribe the same characterization, this being a paramilitary operation with a similar intention, to scene 1. It doesn't become a paramilitary operation after scene 1. If it's a paramilitary operation, with respect, Chair, it's a paramilitary operation from the outset. It may not have been with the aim of annihilating those who were perceived as the enemy until scene 2, but at the very least, if the evidence leaders are correct that this was such an operation at scene 2, you can subscribe some form of intention on the part of Brigadier Carlitz, who was ultimately in control of that paramilitary operation. So, Chair, we do make the submission that this was the product of intention and that you should ultimately find under those circumstances that that SAPS acted with at least dolus eventualis in relation to what happened at scene 1. Chair, there's one further aspect which I might just mention, which I don't address because my learned friends for the injured and arrested are going to deal with, is that we do differ somewhat from the approach that various parties have taken to the correct test to be applied for whether the person acted whether TRT members acted in putative self-defense at scene 1. My learned friend, Mr. Mpofu, is going to be addressing that question, and for the reasons that he will advance during his address, we say that the TRT members did not act in putative self-defense at scene 1. Chair, may I then just turn briefly to two issues that I need to sweep up?
Keeping an eye on the time, you did say you'd be 20 minutes, so it feels a bit longer than that, but may have been that, in fact, it's just caused by the intensity of the argument that made me think it was longer. But how much time have you
Chair,
got?
I need a minute to make reference to the points. Chair, the one point is that in paragraphs 356 and 358 of NUM's heads of argument, the submission is made that this commission should recommend a centralized bargaining, to make recommendations to organized labor, business and the state, that there's a need for centralized bargaining. And we do submit that that is not an issue which is free from contention. It was not the subject of detailed debate in the commission. It was supposed to be dealt with in the phase 2 proceedings. And we submit that it should not, in fact, be a recommendation that is made. Ultimately, it's a NUM policy, one which...
policy, it's not an AMCU policy. AMCU are opposed to it, as I understand it, and there are arguments on either way. The smaller mine owners don't like it because they might be forced into doing things which are all right for the bigger mine owners, but not for the smaller mine owners. On the other hand, there are arguments that it seems to work quite well in the coal and gold sectors. But your point is that we can't really, on the material before us, give a definitive opinion, and we should refrain. Is that
Indeed.
Right?
Chair, there's one final issue which I should just mention, is that there are submissions in NUM's heads of argument in relation to the composition of the strikers on the day, on the 16th of August. We, in fact, prepared heads of argument about a month ago on this question, and we will make that available to you. The simple point is we don't agree with the submissions that are made in relation to the composition of the strikers, either in NUM's heads of argument or in the Phase 2 preliminary report, that the vast majority of strikers on the COPI were AMCU members. And we made submissions in writing earlier, but those don't seem to have been made available as yet to all the parties. So
Look forward to receiving those. Thank you.
thank you, Chair, and apologies for going over time. Those are our submissions.
The apologies are really due to Mr. Nsibeza, not to me, but thank you very much. Mr. Nsibeza, we will accede to your request that we shouldn't take more than half an hour for lunch. And I did indicate to you in chambers when you came to see me about the application of more time, or problems you were having with time, that one aspect you don't have to deal with very fully is the question of the details with respect of each of the 37 deceased persons for whose families you appear. We have undertaken to do our best in our report to set out, to have a section dealing with each of the 44 deceased persons, with our findings in respect to the circumstances in which they died, whether they were employed by Lonmin, if so, in what capacity, and so forth. You've actually broken the back of that. We're very grateful to you and those who have assisted you for compiling that part of the heads, which is going to lighten our task considerably. You don't have to cover it in detail, but you can be assured, and your clients can be assured, that information will certainly be given intensive attention and consideration when our report is drafted. I want to thank you and your colleagues for all the work that was done, which will help us, as I've said, quite considerably.
Thank you, Mr. Chairman. May I also, on behalf of my clients and those who instruct me, thank you, Mr. Chairman, and your commissioners, for the undertaking that you are making. As you well realize, there are 37 families, or families of 37 mine workers were killed between the 13th and the 16th, and a family of each of whom is keen to know whether there was any lawfulness in the killing of their loved ones, let alone justification for those killings.
Same points apply, of course, to the families of the other 7.
Indeed,
we
my
also deal with them as well.
Indeed, Mr. Chair, I can only speak for those that I'm acting, but I share the sentiment. The families of the police, the same families of the security people. Mr. Chair, for housekeeping purposes, I will indicate the material that we want to rely on, but just so that it is known where we stand with respect to the submissions made by the evidence leaders relative to whether it was a function of chaos in scene 1 that the mine workers were channeled to what the evidence leaders themselves call a fuselage of 2 TRT firing. We have dealt with this topic very extensively, and may I just refer you to it? I'm not going to go there. In our reply heads, in paragraphs 31 to 33, we articulate why it is so that what happened in the channeling, the perfected block, was in fact a function of intention and not a function of a haphazard chaos that may have haphazard execution of the plan. And therefore we align ourselves with what Mr. Gotts has said towards the tail end of his submissions. Now, we will want, for our main argument, to rely on the following material. There is a short video clip coming from Exhibit T4, I will give the references now. And we would also like to hand up, and these are ready, Chair, the following latest post-mortem reports, specifically for Mr. Joganisi, Mr. Sokanyile. There are latest post-mortem reports that have come available. And you will have noticed that in our heads we deal with those deaths insofar as there is equivocation as to whether they were inflicted unlawfully or not. We also have got documents which are submissions by Amnesty International, which we crave leave to hand up.
I'm not sure that we have received a document from Amnesty International. In fact, the Secretary is in the process of writing to Amnesty International to thank them for the submissions which we received. There's only one document that we got, which is a very helpful document. And we also got a document from Mr. David Bruce. I requested that the material of this kind we got should be communicated to all the participants of the Commission, so they'll know what we've got and deal with it if they wish. But the Amnesty International document, I think, unless you've got something else as well, we've got an Amnesty International report, and we've, as I've said, the Secretary, that has already been drafted. The Secretary is in the process of sending it to Amnesty International to thank them, and also to Mr. Bruce for his contribution.
Well, Mr. Chair, if you have them, then it is in fact, it's indeed our pleasure that you should have them, because I think they will go a long way to assisting the Commission in its work. Then we also would like to hand up to yourselves a schedule of fresh versus traditional markings from Exhibit KKK 10, which is an exhibit which was compiled by the South African Police Service itself, relevant to the post-mortem on the people who had died. And we will want to make an analysis of what that says and what means, and what the Commission should have regards thereto. Also, like the representatives of AMCU, we will hand up a copy of the oral notes that we prepared in support of this evidence, which will go.
Thank you. That will be very helpful.
Yeah, for those areas that I will not have reached because of time constraint, I'm sure the oral notes will assist the Commission.
I should say this because your clients are possibly not quite as knowledgeable about how things work in courts and commissions. I think I should say, and I take it this will be interpreted to them, that what we have said from the beginning of this part of our work is that the arguments that we ask for are really the written arguments, which are very full. The purpose of this sitting is for highlighting and for Council to be able to answer questions and queries that we've got to put. So the parties concerned mustn't think the mere fact that a matter hasn't been dealt with in this oral hearing means it's been ignored. On the contrary, every single sentence in the written heads will be carefully studied and considered and debated by my colleagues and myself. I think that's important that everybody should know that, but particularly, I think, your clients and possibly the clients who were involved in who suffered as a result of the death of the other 7 people for whom you, in respect to whom you do not appear. But it's very important they should understand that. That's why I put it on record.
Thank you, Mr. Chair. Mr. Chairman, Commissioners Hemraj and Dokota, at the beginning of this commission, we did mention by name, and I think we are going to do so today, albeit fleetingly, who it is whom we represent. It is important because in the hustle and bustle of argument, sometimes it becomes People become statistics. We talk about 37 people whom we represent. There were 3 people who died on the 13th. And those are Tembela Kemati, Semi Joganis, Pumzile Sokanyele. Their relatives are here, whether they are brothers or sisters, fathers or mothers, nephews, nieces, or just members of their extended families. And the difference between everybody else here is that our people, those relatives, those families, are keen to know what at the end of the day it is that is going to be found as to why their loved ones were killed. Because it is not a contest that they were killed. The issue is whether they were killed lawfully or unlawfully. And in the 2 years that they have been sitting here and listening to the evidence that was read, that was led, analyzed, they are keen to know in what way it can be said that those who were killed by the police, and that is also not something that is an issue, except that at one stage the Commissioner of Police once called into question as to whether it was by the police or not. But it's settled now that those families whom we represent were killed by the police, whether they were killed with any lawfulness, justification. And we will argue at the end of it all that each and every one of the 3 I've mentioned and each and every one of the 33 I will mention were killed unlawfully. And we'll set out why we say they were unlawfully killed. 33 of the people whom we represent died on the 13th of August. On the 16th. Stelega, Mary Gadlel, Tim Gosi Gwelani, Petrika Kona Jijase, Jackson Lehupa, Raphael, Janevege Liao, Mafolisi, Mabia, Tokoti Mangojwa, Anele Mdizeni, Bongani Mdze, Makhosandile Mkhonjwa, Telang Mohai, Kanare Elias Monesa, Tabiso Johannes Mosebetsane, Tobile Mpumza, Babalo Mchazi, Michael Ngweyi, Mpumzeni Ngande, Ntandazo Nokamba, Mgcineni Noki, Bongani Nqongophele, Mongezeleli Mteneja, Andris Mfenyeho, Mlifi Osiel Ntswele, Henry Mvuyisi Phato, Modiswatsile van Veek Sagalala, Fezile David Sapendu, Mzukisi Sompeta, Tabiso Johannes Telejane, Mpangeli Tukuza, Nkosi yabo Xhalabile, Ebisile Yawa, Bongi Nkosi Yona, Tobisile Zibambele. All of these people who were unlawfully killed in our submission by the police on the 16th of August were mine workers. They had been drafted from mainly the Transkei, but also from surrounding territories, Swaziland, Lesotho. I don't think there was anyone from Botswana. These had been drafted, and I use the word advisedly, by means of a system, the migratory labor system, which dates back to the discovery of gold in 1886.
Diamonds, 1870.
Well, diamonds, but our submission, given where we are talking about, will be there was an intensification of the use of migrant labor after the discovery of gold in the reef in 1886. In fact, as we put it to Cyril Ramaphosa when he was testifying, it was the Glen Grey Act passed by the Cape Parliament in 1894 that created what was euphemistically called reserves, which Deputy President Ramaphosa was able to agree with me was indeed a euphemism for these places being, in fact, reservoirs for cheap labor. That's what they were. The Glen Grey Act wanted to end the independence of the peasant small-scale farmer. He was going to have to be forced to come to the mining areas, to the reef, as a laborer. The conditions when they came here, and this is more something that would have featured, Mr. Chairman, in phase 2 of your work, but we never got to that. But you have evidence, particularly from the Deputy President, who agreed that this was a system which was abhorrent. Those who came here and became mine workers were kept in compounds which were a little better, if at all, than prisons. They were not permitted to live with their families. They lived in the most dehumanizing circumstances. And you can understand that this was at the beginning of, or at the end of the 19th century. But as you saw in your inspection in Locom, Mr. Chairman, those conditions have barely changed. The places in which the mine workers are kept, save for those that have been cosmetically altered into so-called family units. But the majority of the places that you visit and saw are still compounds. People who are mine workers stay there without any family. They still are dehumanizing. And the question you must ask yourself is, why does this happen in a democracy? Why are we still having a perpetuation of this kind of conditions of service and living for mine workers? Mr. Berger, yesterday, was man enough, Mr. Chair, to admit that the appalling conditions under which mine workers still live in the mines are inexcusable. I think that's the word he used. And we say so. We agree with him fully there. We're saying these are not the conditions that you would expect ordinary human beings to have lived in. And again, we say, it is important to contextualize who these people are. Who are these mine workers? We're talking about people who, by reason of the low wages that they were getting, could never earn enough other than just to sustain them and to have a little bit to support their families with whom they were not staying. But that condition would be perpetuated In fact, in one of the clips that we will show, Makidiwane captures this, that if you are a migrant worker, you are going to pass that legacy forever. Your own children and your children's children will continue to work in the conditions under which. And why is this so in a democracy? Mr. Chairman, Commissioners, it may well be that it is not different from what the author of a book entitled Learning to Trust Democracy, which was published in 1999. The author is Michael Rebehin. He says, what we now have in the new South Africa, and that he said in 10 years ago, in 1999, that inexorably the new South Africa has been heading towards an escalation of socio-economic stratification. He says that the new socio-economic stratification will not be along the traditional lines of a white ruling class versus the African underclass. He predicted that it will assume the new profile of an African white upper class dominating the bloated state apparatus and the business sector versus a largely African underclass consisting of those who were not rewarded with a government job for their participation in the struggle and those who are unemployable because they lack qualifications. Mr. Chair, in the profiles of those who died and the families whom we represent, it may well be that what Michael Rebehin says about them being the African underclass, that this is who they are. But even so, Mr. Chairman, even so, the question remains. In a democracy founded on the values of equality, freedom, human dignity, a democracy informed by the values of Ubuntu, how does it happen that a labor dispute escalates to a point where in that very week 44 human lives are taken? 34 in one day. What is the function of a police service in a democracy founded on those values? How does it deal with what it perceives to be unlawfulness or lawlessness? These are the answers that these families are expecting the Commission to assist them with. Because they were devastated by the events that form part of your inquiry.
Mr. Sabesi, is this an appropriate stage for us to take the lunch, Chairman?
30 minutes, Mr. Chairman.
At 1:30, then you can continue with your arguments.
Thanks, Mr. Chairman.
Sure, that was a good opening.